Good evening. It's the Fit Lawyer ATL, and we are live. I am back in the hotel room here in Collin County, Texas, as I flew into town on Tuesday for Karmelo Anthony's motion to recuse and motion for new trial. So today was day one of the motion for new trial. So come on into the room so you can get the updates. All right, shout out. I think the first person we had in here today was Cool Cup TV LLC. Says, if you're reading this, you're blessed. Thank you so much for sending that. Crawley X2655 says, you know what? Give him a new trial. I think the character of both Austin and Karmelo both come to light in a new trial. That agreement was dumb to begin with. All right. And so we're going to get into what she's talking about, right? Because there was a lot of evidence that came out today in court about the extrinsic or bad character evidence on both sides of this case. So we are 88 in the chat already. Like, share, and subscribe when you come into the live so this can get into the algorithm, and we'll get going with the updates. Lisa Snipe, shout out to the mod in the house. She says hello everyone. Was it Lamitrius 4011? Send some haze. Thank you for joining us. The Ill Made Night says, I want to know why the kid who knew Karmelo testified that Austin was like a big brother to him when Austin was calling him the N-word in his text. Yes, you have already heard some of the tea that we're going to talk about today that came out. Yeah, we were all shocked to hear. And if you checked out my live that I gave during the lunch break, that Karmelo had certain things in his phone, which I already knew that is what it was going to be. But when we came back from the lunch break, Russell Wilson went through page after page after page of bad character evidence on Austin and Hunter, and it was unbelievable. Like, things like they have been suspended every year for like 7 years straight, either in school suspension or out of school suspension. They have been kicked off of other athletic teams. Teachers had complained about them. They were cursing out teachers, cursing out their mom, cussing about their dad, threatening their parents. It was just unbelievable. I can't believe that the defense in the first trial entered into the gentleman's agreement. So we're going to get all into it. So make sure y'all come on into the room. Paraxy 2367 says, let's go, #Melo. Miss Candy says, good evening, everyone. Come on into the room. Teresa Wright, 828, who just joined the channel, is a member. Last live, thank you so much. She is back and says, hello, everyone. I did get to meet some people at the courthouse today, too, that watched the live from last night. If y'all haven't checked that out, we had a great breakdown over the motion for new trial. So go review. Shout out to Jersey Girl Trey, one of our mods in the chat. Shout out. Thank you so much. Make sure you like, share, and subscribe. So before I get started, I have Dennis Byron in the backstage as well. Dennis has some questions. Okay, so I'm going to bring him up because, you know, what I've been kind of doing since I've been down here is checking in with some other YouTube creators, coming up on their YouTubes, kind of sharing as well what I go over on my channel. But today, y'all, when I left court, I was like, I don't want to talk. Give me a break. Like, we were in court today from 9 to 6:30, and we had to be back in the morning at 9. And I'd been there actually since about 4-ish because I had to get in line this morning to get a ticket to get inside the courtroom. So this has been a very long day. So come on into the room, like, share, and subscribe as we get into this. And if this is your first time here, my name is the Fit Lawyer ATL. I am a 20-year criminal defense attorney, personal injury in Atlanta, Georgia. And so I have my own practice, the Adams Firm. So if you ever get arrested for a crime in Georgia or involved in a crash or a slip and fall, give us a call. The information is in the description. All right, so I'm going to bring Dennis up, and we are going to get into what occurred today. Dennis, how you doing?
Hey, how are you?
Oh, man.
First of all, you did an outstanding job as always. You know, that 20 years definitely showed out today in
Thank
your
you.
experience in covering trials. You know, you come from, it's interesting. You watch people report on stories, but you have mastered the art of telling the story because you've had to do this in your profession for many years.
Yeah.
And I commend you for your diligence and your passion for this, because it's one thing you had to come in there to represent clients. It's another thing when you had to convey this, like you're literally doing a presentation to the world.
Yeah. Because, I did my PowerPoints and everything. So I really try to make sure I break it down and make sure that lay people can understand. Because, I'm in a small number, right, being a lawyer, but most of the people make the population are lay people. They don't understand, but they're interested about what's going on, and they want to make sure that justice is being served. So I really want to make sure that I give them, the breakdown. I hear some echo. Is that you?
I don't think it's me because I don't, I'm not using a headphone. Maybe I should use a headphone, perhaps.
I don't know. I just hear something when I'm talking. Ever since you came up, now I hear something in the background. Yeah, I don't hear it now. Yeah, it's you. It's you. It's on your end.
I'm gonna grab some headphones. Talk to the.
Okay. We'll bring Dennis back up once he gets his headphones together. All right, y'all. So let me just take you through the days. So it played just like yesterday. We got in line at 6 a.m. They start handing out these cards. Yesterday I was number 37. Today I was number 19. Hopefully tomorrow, even earlier number than that. We'll see. And so the first 40 get inside the courtroom. Everyone else starts the line for the overflow. So that's how that works. So we are let into the actual courthouse itself at 7 a.m. And this is just people here for the Karmelo Anthony hearing. Other people, but you know what? They get started early in Collin County. So some people were coming in that had probation hearings and checking with probation officers that early. So they get us in and screen and kind of out the way. And then they start dealing with everything else for the court that day. So we get inside at 7 and then we have to wait because court doesn't start till 9. So it's a lot of hurry up and wait to get to this hearing. 8:29 today. This judge had a sketch artist. I was really surprised because this lady walks up. She has this big portfolio and kind of like, well, she doesn't look like media and she wasn't in line with us. Who is she? Get a sketch artist. So they had a sketch artist. I think some of those pictures have already started coming out online. So that person went in first. The dream team, as everyone affectionately calls them, which is Karmelo Anthony's. Okay, I think Dennis is back. Karmelo Anthony's legal team. They came in about 8:29. They arrived, and then they're there earlier because they come in a back door, but they don't come into the courtroom until about 8:30. And then they let in media. That was about 8:32. And then they lined the public up to come in. So we have to get in line in numerical order before we get we get the cards to come into the courthouse. And then they give us badges that we put on lanyards. And so we lined up to get the lanyards and we have to be in numerical order. And when I get in line, I'm sitting there and I'm behind 2 Black females. And I'm like, I don't know why the one with the dreads, she was just dress like twisted up, and I'm like, I know this person, like, who is this? And then when I see them together, I'm like, oh my God, Janetta Brantley. So I don't know if y'all been following the Nolan Wells case, but the lady who took the CETO call and broke it down and enhanced the call and all of that, she was here. So her and her girlfriend were here today. They actually got it into the courthouse today. They were in the overflow room, I heard yesterday. So they are in town to witness, kind of what's going on as well with the Karmelo Anthony hearing. So that was really interesting. So I got the information. So we shall see. Stay tuned. And then Karmelo's family goes in at 8:45. And I didn't see, okay. So yesterday when Karmelo's family came in, everybody had all these cheers and claps, and the deputies were like, okay, calm all that down. So today, before they even walked out, the deputies brought everybody over and they're like, hey, look, when their family comes around, I don't want to do all of the noise, no noise and no hand signals. So people that were there to support lined up, watched the family come in. Some people put their fists in the air, and then the family went in. I didn't see the Metcalfs go in today. Obviously they did, but I just didn't, I didn't notice it. I guess we were lining up. I didn't pay attention to that today. And then they started letting us come in. So we come in. Court started yesterday, like right at 9. Today, because I was able mistakenly had my watch on, so I was able to keep up with the time till about 11. So I can tell you that court didn't start today until about 9:20 or so, when yesterday we started right on time. So it looks like when we came in today, the prosecutors and which were Bill Worski, and I don't know the names of the other ones because he's the only one that spoke. I think Dewey Mitchell is another one that was there at the trial, and there was a female on their side. It was about 4. And they were huddling, discussing something. Russell Wilson was huddled with the defense and they were discussing something. But what I did notice, like Russell Wilson, this is the defense's motion. So they've come in, they got a box of evidence. They got all these exhibits they're going to admit. Every attorney at the table, it was Russell Wilson, Mike, I don't know his last name, and then Justin. I think is it Justin Moore? I can't remember Justin's last name, but so they're at the table and they all have a folder in front of them, right, with all of this information. And on the state side, it's like one little white binder, because it's like they didn't respond in this case. It's not their motion, so they're not bringing in all of this evidence. They didn't have any exhibits that they entered. They're just here making legal argument. So it's just telling to kind of see, who's prepared and who's bringing all this evidence and stuff in. So like I say, they were conferring, huddled up, and then Bill Werski and Russell Wilson, who is the lead of the defense appeals team, started conferring. They started talking to each other. And first they were facing the crowd. And I think Russell Wilson looked up and realized that everybody was like this. Because we were trying to read lips, trying to understand what they were saying. So he turned around and then they talked for a few more minutes and then they disappeared. So they went to the back to have a meeting with the judge in chambers. And whatever they discussed, and I believe it had something to do with disclosure, the amended order that the judge issued. It was kind of more like a stipulation kind of conversation is what they had. So they do that, they come back out. So we're all kind of like, what's going on? What's going on? Because like I said, yesterday things started exactly on time. And so we're like, okay, what's going on? What's going on? Then they bring Karmelo out and the judge comes out. Let me see, did I write down what time the judge came out? I will say yesterday I sat on the left side, so I was behind Jeff Metcalf. This time I sat behind Karmelo's parents. So I was 2 rows behind them and they were on the inside of the aisle this time versus yesterday being on the out. So, which was cool because I kind of got to hear what they were talking about, the kind of whispers between the family. They were in very good spirits today. I would say yesterday when they came into the courtroom, it kind of felt, they don't know what's going to happen, right? They're trying to recuse Judge Roach. They're coming in feeling like, things have been unfair. It's been a bias. Karmelo didn't get a good, fair, just trial is what they're feeling. They just it was real somber because they're quiet. They don't know what's going to happen. But now that they won the motion to recuse, today was it was like a relief. They were lighter. They were laughing. They were jovial. They were, it's like they could breathe and relax because they feel like they're on the road to getting justice. And so you could just tell that stark difference in the entire Carmelo Anthony's family and supporter side today. What, have you heard anything about that, Dennis?
Well, I saw the energy. Are we echoing now?
Huh?
Are we echoing?
No, not at all.
Okay, so what I saw from outside, the people that were streaming, it did look like the energy was more upbeat.
Yeah.
People were moving with a purpose.
Yeah.
And I was watching early. Like, what time were we up? 4 in the morning?
Yes. It was an early start to the day. We were in line at 4. I think I sent you a video like at 4:45
right,
of everybody in line outside.
So I knew that today was a crucial day for the family because we need to see what this dream team really had, up their sleeve, and you can go into how well they did, call the balls and the strikes.
They're saying that your voice is very low. I can hear you, but they're saying that you're coming through low. They can barely hear you.
Okay, how about now?
I think that probably changed it, yeah.
Is that better?
Yeah, it does sound better and stronger.
Okay, so I think that people were really, from yesterday, a judge being recused to the day where now you got past the first prong. Now what's next?
Mm-hmm. Mm-hmm.
And that's now you're gonna tell the world what was next. How did it start out? Because it did seem like from the start the prosecution was attacking maybe some of the people in the courtroom.
They were. It got really, really petty today. Like Bill Werski was defensive today. He was very petty in the sense of calling out content creators by name, speaking negatively about content creators by name. I was really shocked because that doesn't have anything to do with the motion, right? The motion for new trial was today, and the defense raised 4 big issues. And their issues that they were raising were, one, that the judge closed the courtroom in the trial proceedings. And whenever you do that, the law requires that you have findings of fact on the record, the Waller findings. So that Waller term was thrown around a lot. The second argument was this gentleman's agreement that they entered during the trial that the state, they say, reneged on when it got time for Karmelo to testify, and they benefited solely from this agreement. So how dare you renege on it now, because the defense has operated under this agreement. They haven't cross-examined your witnesses. They didn't enter all this bad character evidence against Austin, and then you want to take it away when Karmelo gets ready to testify. So it switched how the defense, had to operate. Karmelo didn't testify, which greatly hurt his case. And so that was their second argument. The third being that the judge gave an improper jury charge when it came to provocation. And then the fourth, the cumulative effect of all of those errors deserves Karmelo Anthony a new trial. So that's what we were here to deal with today. And none of that has anything to do with content creators that were taking shots from Bill Werski all day long. All right. So we're going to talk about that as well. Let me go through my notes. So I was talking about the parents. So they seem to be in great spirits today. They were uplifted versus how they came into it yesterday. I was shocked when they brought Karmelo out today. He was in a suit. Karmelo was suited and booted. Yesterday he came out shackled in forest dark green like jail jumpsuit, but today he was in a navy blue suit with a white top. So was Russell Wilson. So was Mike Howard. I don't know if that was planned or what, but Russell Wilson had on a navy blue suit with a white top, and so did Mike Howard. So Karmelo looks as how he did at trial. He doesn't look like a defendant that's serving time because he's not handcuffed. They did ask for the handcuffs to be removed again today. So he was handcuffed. They take the handcuffs around his waist, and then they shackle his hands to the waist handcuffs. So they removed that. Now he did remain shackled at his feet. They did keep those on the whole time, but he's there in a suit today versus, county blues is what we typically call them, right? So,
and I'm wondering, how did that happen? Because we know from covering, being in like Fulton County, unless you're on trial, they'll bring you in with especially if you went up down the road, you're going to keep the prison garb on even throughout the hearing. So something happened. This judge allowed that to happen.
Yeah. And his attorneys had the clothes there prepared. So yesterday was a motion to recuse. It was very quick. It wasn't any witnesses testifying. It was very simple. They played the 18-minute interview that Judge Roach did on the local news station 2 days after trial, and then it was legal argument. So I guess in that sense, right, we don't need them dressed out. We're not going to be here all day. Witnesses aren't coming in. And then when they get a new judge, they're like, let's make this presentation, okay? So while Karmelo came in suited and booted, this new judge came in as well with a new, fresh attitude. Judge Chitty, is B. Michael Chitty out of Kaufman County. He's a retired judge, but several times, and you see it all the time, Dennis, in Fulton County, they'll call in retired judges to handle dockets when people are out, like substitute teachers, or in matters such as this, when they need to bring somebody outside of the county. So the administrative judge in Texas has been very sure to show that there's no bias in the post-conviction hearing. So he's bringing in judges that have no relationship to Collin County. And it may seem that, a judge from a county over, that's like 30 minutes away. No, we're in Texas. Okay. So city to city, go ahead.
That brings me to my next question.
Mm-hmm.
If the judge grants a new trial, do you think there will be an application for a change of venue?
Yes, I do. And the reason being, if the judge grants the motion for new trial, it's a Collin County case. So it stays in Collin County. Well, now you got to get a new jury that hasn't heard anything. So in order to do that, I think you kind of got to, at this point, get outside of Collin County, because not only was this something that happened here, track meet. There's people here that are coming to watch this trial whose kids were there at the track meet, or they ran with Karmelo. So it's a small town, even Frisco being over where the incident happened in Frisco, but it sits inside of Collin County. So I think you have to go outside of the county just to get new jurors. A lot of people are confused, like, he gets a new trial, he may get more time. The thing with a new trial, the law says says that the new jury can't know anything about this being a new trial. So when the new jury is chosen, they're going to come in fresh eyes. They're not going to know anything about this case. And I know it seems like, what do you mean? There's 545 people in the chat right now. You know, like everybody's following this on YouTube. We've all, but no, it's like 8 billion people in the world. So everybody hasn't been following this. So you can get some jurors that don't know anything about this case. And that's what it will be on a new trial. They won't be able to mention the previous trial. Karmelo will go all the way back to the beginning to arraignment. So a new trial is a fresh start, right? And they get to come into it. The evidence stays the same, but we're going to get into this gentleman's agreement, and you're going to find out what all was kept out of this original trial that's going to be up for fair game if they have another trial. So yes, it will be, I believe it'll be a change of venue if he's given a new trial, because they got to find some impartial jurors.
Yeah, that's going to be hard in Collin County because
very hard.
a lot of press went out after the conviction, so.
And you know, the judge did an interview on a local news station here in Collin County that just came on like after the 6 o'clock news. Like it was just a local news station that did this interview, and then he started releasing. There's actual, if you Google Karmelo Anthony Collin County page, there's a website dedicated to this trial set up by the county. So they upload everything on this website: the trial transcript, video, the audio files from the exhibits at trial, the orders from today. Like you can go right now and go look at this stuff. So it'd be very hard to retry this in Collin County and get an unbiased jury.
Now,
so
you brought up another point just when you said that. So if there is a new trial and they change venue, then should that website be scrubbed up into the point of the new trial order?
Oh, I see what you're saying, right? Yeah, taking everything down. So it would have to be at that point, right? Because it's just too easy access for jurors to get to this information. So they probably would take it down until they got through with the next trial. Yeah. Okay, so they're still saying they can't really hear you, Dennis, and that's weird because I can hear you. So
well, I'm gonna be on the system, a big system in a minute. So when I switch over, they'll hear me better. But right now, I just want to listen to you.
Okay. All right. Well, there we go. All right. So also, so I told you I was sitting behind Karmelo Anthony's parents, and on the second row were family and friends. So I overheard that Drew Anthony's mother was in town. I think they were here yesterday. I'm not sure if they were in the courtroom or overflow, but because some of the family, everybody can't fit in the courtroom. So some of the family is in the overflow room. So they have a lot of support here, and they're actually getting a chance to come in and be a part of it when, you know, they were kept out of the original trial. Like grandma couldn't come to the original trial because when the order said that the family was supposed to have 15 seats aside, it didn't go that way. So I believe Karmelo's family only had like 8 or 7 seats at the trial. So that is also an issue they're raising in the public trial issue. So let me see, 9/17, they started the feed to the ceremonial room. That's the overflow room. It holds about 150 people. Okay, talked about Karmelo coming out. So the judge came out they come back out from chambers from having this meeting about 9:27, and I think the judge came out at 9:34. So we got started late today. Okay, so we got started 30 minutes late. The judge enters, but when he enters and sits down, he introduces himself. You know, hello, my name is Judge Michael Chitty. I am from Kaufman County. I have 22 years of experience, and called the case. So he put the case name on the record. He then calls in Russell Schaefer, who's the public information officer right now that's in place, handling media requests, getting information out to the public, update that website. That's Russell Schaefer. He actually emailed me this morning, or like yesterday, sent me orders because I filled out a media request to get information about these hearings and try to get on the media list. But, you know, they only are letting like news stations come in, but one day. So he brought him inside. And so the judge says on the record, he says, yesterday, the defense filed a motion asking me to live stream this hearing and to have an overflow room because, you know, we didn't know who the judge was going to be until after the motion to recuse and the administrative judge appointed someone new. So once that judge was appointed, they then asked that judge to, you know, grant the overflow, open the courtroom, do the live stream. Well, they did a proposed order that already had the live streaming is in paragraph 7 of this order. Well, what the judge did was he scratched that out, initialed it, and then signed the order. So that meant everything they asked for, they got, is such as the overflow room with the video and audio feed, but they didn't get a live stream to the public. And so the judge says, I denied the request for the live stream to the public, and I am bringing in Russell Schaefer, the public information officer, to put on the record why it wasn't a possibility. He brings Russell in, he swears him in, puts him under oath, and then Russell testifies about why. He just was standing up. He didn't even sit down because it was going to be a quick statement. But he basically said that the request came yesterday and that in order to set up a live stream, they need 2 weeks notice. So that was the reason they couldn't live stream this. Now, of course, Russell Wilson kind of fired back, right? Because they asked some questions like, you've known about this hearing for a while. He's like, yeah, but I never had a request for a live stream. So I didn't have anything to...
That sounds very sketchy considering, they just finished a high profile media case and there was a request for a live stream
in the trial, but the trial's over. So they're like, every time it's a hearing, you have to make that request anew. And so they're saying, we just got the request and they did just get it because we just got a judge yesterday. So they just got this request. So we have to give them a pass. But the big thing about this is the judge bringing Russell Schaefer out to put that on the record is a Waller finding. So that is what the defense is arguing that the Judge Roach never did in the trial case. And so Russell testifies, they put that on the record. The judge, talks about this paragraph, and then that's it. That's the testimony, right? And so what the judge has accomplished is he's put a restriction on the courtroom, right? Because he said, no live stream, that's a restriction. He did the Waller findings, and I'm going to show everyone really quickly because this is the big argument that the state is making. And so that the defense raises, and the fact that this didn't happen in the underlying trial can get Karmelo a new trial. Okay, so it was very telling when this occurred. All right, so the Waller findings. So this Waller versus Georgia is a case out of the U.S. Supreme Court. It came from Georgia, from Fulton County or DeKalb, because they both are Georgia cases, but I can't remember which county. But it was decided in 1984, went all the way to the U.S. Supreme Court, and it says that whenever you put a restriction on the courtroom closure, you have to do these steps. There has to be some overriding interest that is likely to be prejudiced if the courtroom is fully open. The closure must be no broader than necessary to protect that interest. The trial court must consider reasonable alternatives to closing the proceeding, and the trial court must make findings adequate to support the closure. So the judge, what he did in this case by having Russell come out was putting these findings on the record. He wanted to show to everyone why he couldn't do the live stream, because that was a request made. It was struck out. So it was a restriction on the public access of the courtroom. And so he wanted to put that on the record because that's what the law requires. Okay. So that's the first thing that happens. He testifies, puts it on the record. Once he does that, then the judge turns the case back over to Russell Wilson because this is a defense motion. So the defense gets to go first whenever they file a motion where they have the burden. So the burden of evidence, they have to prove what they're arguing, not beyond a reasonable doubt because it's not a trial, right? But by a preponderance of the evidence. So they have to prove this in order to win their trial. So he allows Russell Wilson to make an opening statement. So his opening statement, he had a PowerPoint. And I was really hoping he could get it to work because the AV system was tripping this morning. So he couldn't, because his PowerPoint yesterday was really effective because it makes it simple. He puts up words, he breaks it down, it's really simple and easy to follow. So they did try to work with this. He rebooted his computer. It was like a whole 10-minute delay. So I told you, the judge didn't come out to 10:30. So now we're about at like 9:45. So we're like, okay. So after about 10 minutes of trying to get this AV system to work so he can show the PowerPoint, Russell Wilson just says, you know what, Judge, I'm going to do my opening without it. And we'll just use it at the closing. We'll figure it out. So he starts his opening. And so And the reason he really wanted to use this PowerPoint was because this judge just got appointed to this case yesterday. He just drove hours. He hasn't had a chance to read the record, the 4 volumes of transcripts. He hasn't had of course, he's read the motion for new trial, but he hasn't had a chance to kind of really, digest all of the information. And so this PowerPoint was going to kind of simplify everything for him. So the openings, I would say, because we don't have a watch, right? We're not clocking it. So I kind of feel like they ran maybe 40 minutes a piece. So yeah, I would say about 40 minutes a piece that the openings went. So Russell Wilson goes first. Let's see where he starts. One thing Russell Wilson did do when Schaefer was on the stand, let me go back. He asked him if they had a live feed today. And he says, yes, we have one going to the ceremony of the overflow room. And then he says, okay, did you have that during the trial? And he said, yes, we had it for jury selection. Okay. And so he's asking him those questions because the argument's going to come when they raise this whole, we had to have a closure. If you can do it today and you could do it for the first 2 days, you could have did it the whole trial. And so the point is that.
That's it right there.
Yeah.
You did it for the whole trial. And we wondered why it wasn't throughout the trial.
Mm-hmm.
What were you protecting?
Yeah. And Russell Wilson even asked him, so you had the option to do this back when you had the trial? And he's like, well, yeah, but he says, we also had the option of live feed, but we never got a request. So they never got a request to consider. But you'll hear the law says that they don't have neither party, and the party is only the state and the defense. So the judge isn't a party to the case. Okay. It's state versus Karmelo. So the parties, they can give the judge reasonable alternatives to consider, or they don't have to. And if they don't have to, but the law still requires the judge to have that conversation with themselves, what are the reasonable alternatives? And if you all recall from Judge Roach's interview, he actually says during that interview, you know what? I could have had an audio feed. But you know what? They would have just taken that and distorted it, meaning the public, everybody who's online talking about it. But that is not a legal reason that you can not have the audio feed because you think we're just going to distort it. That's not what Waller allows. You have to make, what's the overriding interest that you're trying to protect by saying people can distort it? I mean, it's the First Amendment right. I can have an opinion about whatever evidence you put out. You don't get to say I can't hear it because I won't agree with you, or I have a different opinion, or I'll flip it to fit my narrative. I mean, that's not a reason that you can keep me out of the trial. The defendant has a right to a public trial. Let's see. All right. So opening statements. That's when, so Russell Wilson's sitting here, Mike, and I got to get his last name, the appeals attorney, and then Justin is sitting on this side of Karmelo. Karmelo's right here next to Mike. So Mike stands up before Russell Wilson starts his opening and asks the judge, yesterday we had the handcuffs removed. The judge didn't have a problem with it. Do you have a problem with it today? The judge said, oh, of course not. They unhandcuff Karmelo. He sits back down. Then they have the whole PowerPoint. They talk about 40 exhibits. So the defense had admitted exhibits already, like they've already discussed the exhibits with the state so that it doesn't take so much time. They stipulated to these exhibits and entered them. They had 40, but I think they entered 47 exhibits. So 40 or 47 is what they entered. And some of it was like the motion for new trial. They had affidavits attached. So they entered those. They also entered things that we had never seen before. So it'll come up in the discussion about the gentleman's agreement, but a motion in limine, motion to keep out extrinsic evidence against Karmelo. So that 75-page document thing, we saw that today. That was a document that the defense entered into the record. We also saw the, I don't know how many pages it was, but all of the bad stuff about Austin, that was on a document today that the defense had filed in the trial that was kept out. Well, not kept out. It was this shadow docket. So we're going to get into that. But that was part of the things that were in the exhibits today. So those things were admitted.
That would look nice on the big screen.
Yeah, right. It did. They were blowing it out, blowing it up, showing us everything. So I'm going to get into that. And so, Russell Wilson says, and I say Bill Werski was really on one today. Like he was very honorary. Like he just the cuff comments talking about creators and I told you all that Russell was trying to get his AV system to work, trying to get the PowerPoint to work. He says, Judge, I feel like PowerPoints are easier. And then Bill Worski stands up, object to that statement, Judge, that PowerPoints make it easier to understand. Like, so he was already just not in a good mood today. And it just showed throughout the entire day. Towards the end, we all thought he was crying at one point, and I'm going to tell you about that part, but it really sounded like he was getting Bill Worski got choked up and cried when Mike Howard was on the stand, and I'm going to come to that. Okay, so if you all recall, when this motion for new trial was filed, July, I believe 7th, the transcript and the entire case record was in the judge's office, right? The transcript hadn't even been transcribed at that point. The case record, the attorneys couldn't review unless they were in the judge's office. The judge wouldn't let them take anything out from the case file unless they agreed to sign, not like, what was it, an NDA, or they just had to agree not to disclose anything that they saw in the record. And Russell Wilson was like, well, how can I agree not to disclose something until I see what it is? And the judge was like, well, if you're not, this is Judge Roach. If you're not going to agree to that, I'm not going to give you the case file. So the case file was still sealed in the judge's office, even after conviction. And the court reporters hadn't even started the transcript. So when Russell Wilson has 30 days from conviction to do this motion for new trial, they have to work with Mike Howard. They have to work with people in the public to get these affidavits because, one, there's no record, and two, they don't know what happened because we don't have a transcript. So they're working blind trying to come up with this document. So they reference that today to say, Judge, we've amended, or we have some additional arguments and some additional things and some corrections because we didn't have the transcript at the time that we prepared our motion. So where Mike Howard in his affidavit said Karmelo only had 10 minutes to make this decision about testifying, turns out it was more close to 30 minutes, a gap, and they know that once they get the transcript. So the transcript, you're trying to recall things after a trial, after months of preparation, days of testimony, you're trying to recall it from your head. So they didn't have everything exactly accurate, but nothing new came out that changed their legal arguments.
I mean, the fact that this judge knew that these attorneys need a roadmap to prepare for whatever they had to do as far as a new trial motion or anything, he would actually sit on the files until, why would an attorney would agree to that? Like,
exactly, like why, and why was it even being set on? And the problem was that, and what Bill Worski said when it got to be his opening time, is that they did a lot of stuff in this trial that they didn't call it shady, right? They're not going to say that, but they did a lot of things that don't occur in other trials that you probably never heard about in other trials because they got so many death threats. They got threats. They had outsiders trying to influence everything. So they held on to this case tight to the vest to try to protect Karmelo, try to save Karmelo, try to save the case. So that is kind of what the state is going to say. I'm going to come to that argument second because, I was so surprised to hear it. It wasn't any law, but it was all of these excuses as to why they moved in secret in everything that they did with this case. So Russell Wilson goes through their arguments that they're going to make. He also says during his argument, we talk about how the hearings were closed, that after Karmelo got a bond, which was about 2 weeks after the incident occurred, he got no bond. He got $1 million bond at first. And then a couple of weeks later, he came back before a judge, a black female judge, I believe. She was a black female judge. Okay. She came before a black female judge and she lowered the bond from $1 million to $250,000. And then he bonds out. After that bond out, Karmelo never entered the courthouse for a hearing until trial. Anybody that's been through the criminal justice system know that's some BS, right? Because you got to have a plea and arraignment where you come in and you plead not guilty on the record. You can waive it, but I mean, that's still a court date that you know about, right? So in a murder case, you have several pretrial hearings. You talk about evidence that you want to keep in, evidence that you want to keep out. None of that was done in open court. So Karmelo never attended anything else, but he had his bond hearing and then he showed up for trial. They issued him into the courthouse in secret one day. Sometime last year, they were doing a buccal swab. So they were taking his saliva to test his DNA for, evidence in the case. But they didn't tell anybody that. They snuck him into an office really quick. They did the swab and then they released him. So I was blown away to hear that. He went from bond to trial because they did everything in secret. All of the pretrial hearings that you would typically have in a case were held in the judge's chambers, no court reporter, sometimes over a phone call, but it was just casual conversation about the case between the judges and the attorneys. They didn't have the defendant there for these type of hearings, which is it feels like a violation of the law because he's supposed to be there.
Let's be honest. If we go back, history, years ago, when someone got railroaded, this is what a railroad looks like. This is what a railroad, when you remove all the controls to keep people honest, you remove that, what do you have? You have a railroad. Because there's no checks and balances.
Yeah, there's nobody watching. Nobody saw anything happening. So there's nobody to even question. You see how we're questioning now? Like the Nolan Wells case, right? They're questioning everything in an investigation and everything. Like that's what people can do when they know stuff is happening. They can question it. They can ask to see the evidence and all of that, but you can't when you don't know what's happening. So that's when Russell Wilson introduces the term shadow docket. So he says that the court acted under a shadow docket in this case. Now, Bill Werski took great offense to this, and he doesn't, support the term shadow docket. He calls it a paper docket. So back in the day, let me see, I've been practicing now for 20 years. When I first started practicing in 2006, we had paper dockets, right? There was no e-file system. You had to go to the courthouse by 5 o'clock to get your filed that day to get it. You had to go stand in a window. You had to go to the clerk could take it, stamp it, and you always had to show it with 3 copies because you had to get your copy stamped to leave with them. You had to get a copy stamp for the DA's office that you sometimes had to go take to the DA's office, and then you had a copy that you got stamped to give back to yourself. So that was the whole paper docket method, right? You go to the clerk's office and they would turn around and open up a file cabinet and they pull out your file and it'd be numbered with these sticky numbers on, you know what I'm talking about? Then it's on the side of the folder and they pull them out of the drawer and they get your file out and they say, what do you need?
Absolutely. Their version of the Dewey Decimal System.
Right. So that's a paper docket. So that's how things were back in the day. Well, I can't remember the year that it started, 2010 maybe. They introduced somewhere around there, they started introducing Tyler and Odyssey. And now we have like Peach Court in Georgia, but Tyler and Odyssey are just kind of standard in every state. It is an e-filing system. Now it's mandatory that you have to e-file filings in a case. Like even when you go down to the courthouse in person, most courthouses will have, major city courthouses will have an e-file room where they have a room of computers, and they will sit you at the computer and show you how to e-file it. They don't take a paper filing anymore. Certain counties on outskirts they do, but e-filing is what they mandate in a lot of cases, so that all of the docket is digital, it's electronic, it's on the file, it's on the computer system. So you can log into the Tyler system in Fulton County right now and pull up anyone's case, and you can see the entire docket. When they got a court date coming up, whatever has been filed in that case, you can see it. Well, in this case, they say that, and Bill Werski, when he spoke, talked about how many threats they were getting. The judge that gave a lower bond was doxxed. The person who threatened her the FBI got involved. Like they have somebody in jail, in custody right now, I believe in Idaho, for threatening this judge. So it was a big viral public case. Everyone was getting death threats. His family was getting death threats. They moved one time. So this is why Bill Werski says Judge Roach developed this shadow docket, so that the public wouldn't be aware of every time they had a hearing, so they could show up to the courthouse and they could come in and see everything. But that's exactly why the Sixth Amendment exists, because the defendant is supposed to have public hearings, pretrial hearings, motion hearings. They are supposed to be public. But Judge Roach and the DA and Mike Howard in this case, they were just so concerned. This is what Bill Werski says. They were so concerned with the safety of the defendant. We did all of this to keep everyone safe. And mainly it was Karmelo. We were trying to protect Karmelo. This is what Bill Werski is saying. We acted to make sure that Karmelo survived. And everything we did it for that reason. And Judge, it worked. look, he survived. Like that was his justification for them having this shadow
conveniently they
docket.
did it for him, right? Yeah, conveniently
Right,
they
like
did
you
it
did it
for
for Carmelo. Yes. So that's what Bill Worski says. So, but back to Russell. So he's going through everything and he's saying that this shadow docket started with the indictment. So after the indictments filed, usually, like I said, you have pretrial hearings, other motions. The judge said, no, file them basically via email. So or hand delivery. So basically when Mike Howard prepared a motion, he would walk it over to Bill Worski, hand it to him. That means it's filed. Nobody ever stamped them. And then they would go into the judge's chambers whenever he would call him in to discuss a motion that's been filed, or they would ask the judge for a conversation if they reached an issue that they needed him to rule on, or they would just get summoned to his office to have these in-office meetings to discuss the issues. And when Bill Worski got up, I'm gonna say this statement because I want it to resonate how it came out. But this is what they were doing. So nobody was aware of the court dates. Karmelo was never at any of these meetings. So decisions are being made. These hearings, judge, we're going to keep this out, or they're talking about legal issues. They're not order was in there. They never filed the motions themselves into the record. So okay, we're back. All right, sorry about that, guys. I know what happened with the internet. But if you all recall, the first time I covered this, when we were talking about the motion for new trial, Dennis came up on my show and I said, and I pulled up the docket and I said, look, there's nothing been filed in this case. There's no pretrial hearings. And Dennis told me then, no, I have someone that's let me know there have been hearings, but they haven't filed them on the docket. And that's exactly what occurred in this case. There were hearings, there were conversations. So what happens? You get an appeals attorney, you're trying to go argue stuff, you get a record and it's blank, because none of the motions were filed. So all of these motions that you typed up to make legal arguments, they never got stamped into the record. So they're not a part of the record. So we don't have them. So, and a court reporter didn't take down any of these meetings. So we don't know the logic, the legal reasoning the judge used to reach his issues. We have no clue what they are because it's this shadow docket. So Russell talked about the shadow docket. Talked about, he went through the issues that they raised in the motion and talked about two of them being structural errors where the case has to be overturned if the judge agrees with them. And that's the public trial argument and the jury instruction. And he tells the judge, what you did this morning was a Waller finding. You put on the record why you were not allowing live stream. That never happened in the underlying trial. And that's a major flaw in the case. And they talked about what the court needs in the record to show the Waller findings and how they're not on the record in this case. And if you follow any lives I've done, we have been breaking that down from the beginning. And we said it months ago that when the defense first filed their motion, we broke down the Waller findings, pulled up the judge's amended order, and it doesn't speak to anything. That's what they did. So while they were having this Waller conversation, the state drafted a proposed order and they sent it to Mike Howard. This is during the trial, but it never gets signed. So it never gets signed by a judge. It never gets filed as a part of the record. And they had a copy of it today. And actually, even if it had got signed and put in the record, I don't believe, and this is what Russell Wilson's arguments were, what they said in that order didn't meet Waller findings anyway. So you didn't do it, but you drafted one and never got signed. But even if it had got signed and filed, what you say in this order still doesn't meet Waller findings. And what that order was saying was that it was a draft by a lady, last name Braxton. She's a appeals attorney that works in DA's office. And so she was helping them overcome this Waller issue. Like anybody that knows the law, whenever the judge starts putting some restrictions on a courtroom, that Waller gets in play. So she was trying to make sure that they were following this. And it even came out in testimony that she even told the judge, you need to have an overflow room. You need to have an audio feed. You need to have a live feed so that you are following Waller. And the judge said, no, absolutely not. I'm not doing it for the trial. And so she said, okay, well, let me draft a proposed order. So she was trying to cover the bases to make, to put these findings of facts. But guess what? You play dirty sometimes, you make a lot of errors. So the order never gets signed. Now, when Bill Worski does his opening, he jumps up and he says the order never got signed because Karmelo got a new lawyer the minute he got a verdict. What? No. The closing was done when the amended order was issued. I think it was like April 28th. That is when you're supposed to have the findings. You don't get to do the findings later.
Right, at the end of the trial. It's pointless then.
Right. And so they were trying to say that they left it open just in because they didn't know if they would have to add anything else to the Waller finding. It's like they didn't really have a good understanding of the Waller findings, even though they say they did. You don't wait until you close the courtroom, your closure is over, then you come back and do an order and put your findings as to why. No, at the minute you say you're closing something, that's when the Waller findings, like the judge in this case, he literally just signed the order last night. And the first time he could be on the record, he put on the record as to why he did not do the live stream. And that is exactly what should have happened. You don't get to put it on the record a month later as to why you're closing something when the closure's already happened. So Russell Wilson brought that in his opening statement. Like the openings were long. Like they were really getting into a lot of the legal argument in the openings. Let me go next. And they also mention again how the judge in the amended order, he puts time, place, and manner as being the standard he used in order to determine the closure. The problem is that's not what the law says. It's the wrong standard. So I've said this from the beginning. I don't think Judge Roach from the outset sat down and said, I'm going to close these proceedings. I'm not going to open this so he could purposely do something wrong. I think he really thought he was following the law, and it doesn't appear that they did in this case. Shout out to, let me catch it. Hold on, y'all. Got a super chat. I got a little things in here. Let me just pause for the calls. Lil Mama 3545 sends 2 jewels. Thank you so much, sis, for the jewels. My mod is in the house. Jersey Girl Trey. You always like, share, and subscribe. She's always sharing on social media whenever I get ready to go live. So thank you so much. This was an old one, so Dennis, you're good now, but she was telling you to fix your audio. Shout out Jersey Girl Trey for the $2 super chat. Lil Mama 3545 comes back again with 10 jewels. Thank you so much. Sends a thumbs up. And Legal 2 Cents sends 1,000 jewels. Thank you so much. Thank you. So this is, you're a YouTuber, right? I think that's what that means on the left when the name looks like that. So Legal 2 Cents, shout out, another lawyer possibly in the house. So thank you so much for tuning in. All right, so let me go back. So now, a lot of people, because y'all were coming for me under my Facebook post every time I went live about this motion for new trial, people would say, the courtroom wasn't closed. Karmelo's courtroom was open. Y'all are just making up some blah, blah, blah. Guess what? The party stipulated that there was a closure. Anytime there's an order that's issued that is any type of restrictions, only 9 media, 15 seats for family, on 15 seats for the other family. On time you list and carve out who can or cannot come into the courthouse, or how much you're going to open, or you're not going to do a live feed for anytime you put any order in place that puts restrictions on who can enter.
Like legacy media only.
Yeah, they said only legacy media. They didn't say non-media. They said legacy. So that was putting a restriction on what media could come in. You trigger the Waller factors. And so the state and the defense actually stipulated, and they agree there was a closure. So all of that, you got to prove first it was a closure. I don't know why people thought that it wasn't. There was an actual order issued closing or putting in rules and restrictions to who could enter. So definitely there was a closure. So that's not an argument. So the argument isn't a closure. So they said a closure happened. So now you trigger Waller findings. That's the only thing the judge has to consider under this first. Well, 2 things. He has to. So you trigger Waller findings when there's a closing, but you got to object timely. And so that's the defense's argument. The defense is saying, hey, look, and Bill Worski said this yesterday, the first thing out of his mouth yesterday, the first thing out of his mouth today. Both sides agreed to everything that happened in this case. So I don't care about these new lawyers coming in here, this high power legal team pulling out everything, nicking it apart. The first lawyers agreed to everything that happened in this case. And so that's a problem. So Mike Howard, if you consent it to this amended order closing, not requiring the Waller findings, did you waive the objection to that? Can you bring it up now if you didn't? And so that's going to be some of the discussion that they get into when they had Mike Howard on the stand. Let's see what else. So the shadow docket. Yeah, he talked about how they haven't seen a case ever like this, that so much stuff is missing from the docket. Then they get into this gentleman's agreement. It wasn't reduced to writing. It was all oral. Phone conversations, meetings in persons. So the very agreement that basically ran this entire case, and the gentleman's agreement was, Mike Howard says they would go to these pretrial hearings before the judge, and they come to these conversations, and several times Bill Worski would say, hey, you know what, we can enter into agreement to keep all this out. And Mike Howard would just kind of brush it off, chuckle, like, why the hell will we agree to something like that? Why would we agree to that? He says a few times they just kind of shut it off, like, why would we ever agree to that? And then as they started to get further into the case and go through the discovery that the state served on them and did their own independent investigation, a part of the discovery they received from the state was a phone dump of Karmelo's phone. And as they started going through this phone dump, they started to see bad evidence that Karmelo did that could be used against him. So Mike Howard says when all that came out, and then Bill throws this, hey, got an offer for you. We can keep all that out and just try this case clean, stick to the facts under the tent. Mike says at that point, they saw all this bad stuff that they felt could be used against Karmelo and would be hurtful to his self-defense claim. They jumped at it. They were like, yes, let's take the deal. So Mike, they get this offer. Toby Shook is the I won't say I was about to say co-defendant, but the second chair attorney for the defense team, second chair co-counsel that used to work with Bill Worski, so they had the relationship. They are the ones that got on the phone to work out and iron out this gentleman's agreement. So they kind of go through it on the phone, then they end up meeting in person in a grand jury room. And it seems like it was about 8 people in this room. It's Toby Shook, is Ms. Gupta, is this attorney, is like attorneys for the state. And they have this knockdown, drag out, hash out this gentleman's agreement. And then they meet several more times over the phone, some in person, to kind of iron it out, because what the agreement was, hey, let's try this case clean. Let's keep it to everything that happened under the tent, and that's it. So basically what they were saying was, we're not going to bring up anything outside of that. So no bad stuff about Austin, which there was a lot of things, y'all. I took notes on like 30 something things, but we're going to go through it. But we're going to agree to keep that stuff out. You'd agree to keep out the stuff about Karmelo. Even other things, like we just talk about those 2 things that they kept out a lot more. So a lot of statements, and people online and everything pointed this out, and we questioned it during the trial. Why didn't they cross-examine that witness? Because originally the witness said Austin was the aggressor, or the witness said that Austin and Hunter are known to be bullies. Like, why aren't they bringing that stuff up in trial? Well, they agreed to keep that stuff out. So
let me say this. The exclusion of the quote unquote bad acts on both sides, from your perspective, who do you think's bad acts would have, well, considering he's fighting for his life, do you think as a defense attorney that those bad acts of his outweighed the bad acts of the person that he had to defend himself against? If you had to, would you have made a call like that, knowing the information you know about what was in those bad acts? Would you be comfortable knowing that you're fighting for your client's freedom?
Right.
Would you roll the dice on that?
We're rolling the dice.
Okay.
We're rolling the dice. Before lunch, Bill Worski in his opening let out some stuff about Karmelo. So when I heard it, I was like, oh my God. First, I knew it was some shit on the phone. All right, I've been saying that for months. I'm a criminal defense attorney for the last 20 years. Every criminal case I get, my client has some shit on his phone. I don't care how clean cut he is. I don't care how many scholarships he has from college. These kids have crap on their phone. So I knew that it was that. And Bill Worski kind of dropped kind of what it was. And so he said that Karmelo had text messages in his phone, and we did later see them in the hearing. They were admitted, that talked about a knife, talked about fantasizing. Now, this is how Bill Worski described it. Karmelo had stuff in his phone that, showed he fantasized about stabbing somebody and licking the blood off of the knife. He had pictures with himself with a gun. He had text messages talking about being in fights and shows that he likes to be in fights. This is how Bill Worski is presenting this. So as I'm hearing this, I'm like, oh my God, what? That's horrible. Like, hell yeah, I see why they took the deal, right? Like, that stuff is horrible. What? You wanted to stab someone and lick the blood off the knife? Like, if a juror hears that and then you actually stab somebody, and this is all Bill Worski. This is how they do, right? It's all about what side you're on. So this is how he's presenting the evidence. He says, yeah, Karmelo's girlfriend, he broke up with his girlfriend that night, or at some point. And the morning of the stabbing, 8:30 a.m., this girlfriend or ex-girlfriend goes to an assistant principal at the school and tells them, I'm afraid Karmelo is stalking me. I try to break up with him. He won't take no for an answer. I'm really concerned he's going to do something. And 3 hours later, he stabs Austin. This is how Bill Worski presents it. He says, and then he has these texts about licking the blood off the knife. And basically they say Karmelo was losing it. He was reeling. His girlfriend had broke up with him. He's has stuff on his phone that shows he likes to get into fights. And so he was just itching and waiting for somebody to say something to him that day so he could just snap. So this is how they presented their case. Well, later on in the hearing, when Russell Wilson actually puts the evidence up, it was text messages. So what happened was Karmelo and his girlfriend have some type of argument, but the argument isn't in text, and his phone dies. So when he is able to get the phone onto the charger, then it's like a whole bunch of text messages and stuff go out at like one time or something like that. So it seems to the girlfriend like I'm getting all these messages like he's losing it, but it was only because the phone had died and they didn't go out or something till it synced to the laptop, some shit like that, right? Okay, so but the point is they put the text messages up. This whole lick the knife thing, it was a text message between him and his girlfriend. And so when you see it, you're like, what? And then he said something else like, I'm on the verge.
So let me understand this. The licking the knife was taken out of context?
Well, I mean, no, the text really did say, I want to stab somebody, lick the blood off the knife. It did say this, but it's a text message that he sends to his girlfriend. I don't know the context of what else they were talking about.
But that's still bad. Let's be honest.
It's bad, yeah. Right? But when you saw that, okay, so it's text message evidence. Then they have a picture that Karmelo had on his phone, picture with a gun. You don't know if it's a real gun or not, but these kids today, it's probably a real gun, right? But he's not. He's just bare chested and holding his gun. So the picture that was going around on social media that kind of leaked, that was a real picture.
Okay, so leaked. It was in his phone. Who would have had the opportunity to leak that photo?
Right. Because the state had it and then they gave it to the defense. So I don't know how it got out, but I do recall seeing that picture floating around. So that was on there. And the whole thing about he has stuff on his phone that shows he likes to fight. It was 2 text messages. One, he was telling somebody a story that something happened back in 21 where he punched a girl in the face, but he was saying why it happened. She ended up pushing him. She was picking with him. And then he ended up, doing this. So they're going to try to say like, because you talked about something that happened in 21, it was a real stretch. Okay. A real stretch. And then another one, he talked about getting jumped by some boys because he talked smack about one of the senior football players or something. And they all jumped him. They jumped him. So it wasn't Karmelo fighting somebody else. So when you actually see the text that Bill Worski tries to present is all of this bad evidence against Karmelo, and then I'm going to tell you what came out about Austin, and you're going to tell me what you think. Okay, so we're going to get into that as to why I say you just let all that shit comes out, and you just let the jury decide what they're going to decide about the case at that point. So they go through the gentleman's agreement, and they talk about the big argument about this agreement is that everybody followed the agreement. So even through jury selection, the defense is following not bringing this up. If you all recall, and Russell Wilson talked about this towards the end of today when he had Mike Howard on the stand, Mike Howard made a Batson challenge to the 3 Black female jurors that were struck by the state when they were doing jury selection. It was at the end. It was the last 3 Black jurors. They were teachers, they were educators, and they struck them. And so he raised a Batson challenge by saying, Judge, I believe that this was a racially motivated, strike. Make them give us a race neutral reason. And so the state says their race neutral reason was that they were teachers. A lot of the witnesses testifying were students. This happened at a field, with students. They felt like the teachers may be sensitive to that stuff and may be biased. Well, guess what? Some of the stuff that they kept out about Austin and Hunter were that they used the N-word a lot. And there were a lot of videos on Austin's phone of him bullying Black kids, picking with them, throwing water on them, just messing with Black kids. And he just would record these videos. So now if any of this evidence comes out and you got 3 Black women on the jury, what do you think gonna happen? We're gonna be mad. We're going to be mad. We're going to look at this case, and I'm not going to be sympathetic to Austin. I'm not going to feel so bad, right? If I hear that you're using this N-word, I might feel like Karmelo might have been justified in his actions once I hear all the racial things that you get in trouble for and that you do. So when this Batson argument is raised, because of this gentleman's agreement, Mike Howard couldn't even argue that to the judge. He can't say, Judge, Austin used the N-word, and I think they're striking these jurors because they don't want them to hear this racial stuff that's going to come out about the victim. He can't argue that because they agreed that they weren't going to bring up this character evidence. So Russell Wilson's whole point is the defense was bootstrapped the entire trial and operated under this agreement, all to get to Karmelo getting ready to testify in the state. We never anticipated the defendant testifying. If he testifies, the agreement doesn't cover that, And so they're trying to say that the state, you reap the benefit of the agreement. Your entire case was done and closed. And then when Karmelo gets ready to testify and the defense is doing their thing, now you want to say that they opened the door on opening and you're not going to honor the agreement anymore. That's not fair, is what the defense is arguing. And Russell in his opening was like, that's the problem, Judge. The state got this unfair advantage by operating under this agreement until it was time for Karmelo to testify. Then they don't want to operate under it. And now his attorney can't go back to the beginning. He can't go back and now cross-examine people on inconsistent statements and impeach people that the state called. He can't go back and fix it. So that's what they're saying, like that's a problem, Judge. And that's not structural error, though. That doesn't get you a new trial per se, but they're just raising unfairness that happened in this trial for the judge to see. So that was that point. He starts to get into the provocation issue and how the third element of the provocation was missing. And so the judge shouldn't have given this provocation instruction to the jury. And so before the jury deliberates, the judge gives jury charges. And so the defense's argument is that this prior difficulty provocation charge that they gave was improper. And because it was given improperly, that it swayed the jurors to use the evidence in a way that they shouldn't have, which led to Karmelo's conviction. And that is another structural error and should be overturned. And so that was that in his opening. I was right now like almost every word. Oh, okay. So when they're researching this closure, they said that Roach's interview, that they scanned cases across America, so outside of Texas, and they could not find any closure like the closure in the Karmelo Anthony case that wasn't supported with findings on the record. So they're just basically trying to show the judge like such gross negligence happened in this case that this closure was unsupported by American jurisprudence. Like, I've never heard that before in a case. But Russell Wilson is like, Judge, we did our legal research and we can't find any case across the country that supports how the closure was done in this case. And so then the state, though, disputes this whole thing and says that basically the defense knew about the closure. They didn't raise this argument when the trial was occurring, so they don't get to raise it now. They get into this, and I didn't see at first how it was relevant, but they get into the termination of Mr. Jackson. So remember, I spoke to you all about how the judge brought in Russell Schaefer. He was the public information officer now. Well, the very first public information officer that was put in place when this case first started was a Black man named Derrick Jackson. He basically was the person who designed the Google form that the first media had to fill out to request entry into the trial. He worked with the judge and the county and the DA's office for the 10 months, about 9 months or so, to get ready for the trial. He was the person that was handling all of that. He got in trouble. So what happened? So they bring him. Okay, let me finish though, because I'm getting off track. I just want to stay in order. All right, so that's Russell Wilson's opening. Yeah, now the state gets up. And the first thing out of Bill Werski's mouth is every single decision was with the consent of the trial lawyers. That's his first statement. And he said that yesterday. Judge, I know you're hearing all this stuff that this second team has issues with. The first team was consenting to all of that. So that's his thing. Like, they didn't object to it. They went along with it. And then he goes to say, like, they were looking out for their client. And so they couldn't go through the first trial, benefit from everything, look out for your client. And then now when the verdict doesn't go your way, you get this appeals team, and now y'all are raising issue with everything we did, but you actively participated in everything we did when we did it. And so he said, he has this thing where he uses a lot of, I guess, like Southern terms or whatever, like old school. He said, is too cute by half. That's what he said. I never heard that before. But he does a lot of these little phrases that he uses when he's talking about this. So basically, he's just saying, like, don't be cute now. Like, you benefited from how we handled things. You were basically, Bill Werski says that everybody was so concerned about the threats in this case, about the death threats that Karmelo had. And that's why the judge had this paper docket. That's what he called it. He said it's not a shadow docket. This is a paper docket. So there are actual filings. They were just done in paper. And this is when I told you all earlier that he kept harping on the fact that we were doing all of this to protect Karmelo. He actually said, this is how, he said, let me see, hold on, get this right. He was pissed off about the shadow docket. He said those two words should never be said. He said that's the way we do business in Texas. And he was talking about how they were handling this case with the whole agreements and the phone calls and the meeting chambers to talk about the pretrial hearings. Like, that's how they do business in Texas. So all you outsiders that are the social media people, basically, that are coming in and having a problem with this is how we do things in Texas. And so basically it's saying, like, we didn't do anything wrong here. And that this happens in all the cases here. Like, this is how we move in Texas. But his voice was boisterous and loud when he said, like, that's the way we do business in Texas. So he said there are plenty of off the record convos. That's how we do it here. So when I tell you he was very defensive the entire day, he said, and so, but look, guys, this is his opening statement. So what I took from this is that they did not do the Waller findings, and he wants the judge to look at something else. So when you get up for your opening, Russell Wilson has gone through, he has made his argument. He has said to the judge what you didn't do. He's shown the judge how you didn't put Waller findings on the record. So now it's Bill Werski's time. You get up. This is your first time to argue to the judge that you did do Waller findings. What does he say? Judge, the defense wants to come in here and act like we don't know about Waller findings. That's ridiculous. We of course we know what Waller is. I have the most sophisticated appeals attorney helping us with this. And the only time I was ever overturned on a case is when I let another attorney do my jury charges. I do my own jury charges, and I sat there and researched, and I know about Waller findings. So for them to act like the state doesn't know what Waller is, that's ridiculous. This is what he's saying. But then when he started talking about this record, he didn't go back and say, Judge, here's our Waller findings. He says, Judge, you got to understand why everything in this case happened the way it did. We were trying to keep Mr. Anthony safe. We were trying to keep him alive. We had all of these threats. We were all concerned about safety. So when we have these off the record conversations and we have this paper docket, we're only doing this to save Mr. Anthony's life. So, and it worked. He survived. Like nothing happened to him. And I'm sitting there like,
correct me if I'm wrong.
Where's the findings?
You have the law, the codes, the law, the penal, whatever. Then you have criminal procedure. You have the procedure.
Mm-hmm.
It sounds like they deviate from the procedures, because if you have to have, for example, an electronic filing, a stamp of a document, that's part of the procedure.
Yep.
Seems like this judge deviated from procedure and just winged it.
Yeah.
But did what he wanted to do.
Yeah. And it's like they act like this is the first case like this. They act like this was the first case with media attention. Are you kidding me? The YSL trial in Fulton County, Georgia was the longest, biggest trial in American history. Okay, that was live streamed. 28 defendants. The case went on for a year almost? Like, Judge, what are you talking about? Like, this was a 4 or 5 day trial in little Collin County. Like, because it got so much social media attention, they weren't used to that part. So they weren't used to things going viral. They were just taken aback. Yeah, they were getting threats, but I mean, it happens, right? But so it shouldn't take you off of your mark to how you perform in a case. So, right, to your point, they skirted all of that procedure. But like Bill Worski says, that's the way we do business in Texas. So, but Bill, that ain't how it worked. If the law says and Waller says you have to make these findings. So what I found telling was when it was his turn to jump up and say, Judge, because this is a structural error. If the judge agrees that, well, we already know there was a closure, they stipulated, but if the judge agrees that this is a timely argument, meaning that the defense didn't waive this argument on the trial court level, then you need to be jumping up and explaining to me where the Waller findings are. I mean, I've been before some judges that won't even go through all of that opening stuff. They're like, look, I read the motions. Where's the Waller findings? You need to show me where the Waller findings are. They're like, let's get to the point. Where are the Waller findings? The entire time he stood up for his opening, he just kept showing examples and excuses as to why the Waller findings didn't exist. And they say, Judge, we even drafted a pretrial order. It didn't get signed because Mr. Anthony got new attorneys once he got convicted. As if that's the problem. He kept trying to point and paint the picture like it's everybody else's fault, when no, you, Judge Roach, and Mr. Mike Howard did not have a hearing on this, because remember, y'all were doing it how y'all do it in Texas. So y'all were just having off the record conversations about this closure. So it's not on the record. And while we just pull that up, it requires that you put findings on the record. And so when people hear the word findings on the record, I don't know if you all really understand how important that is. Along with Happily Angry Lawyer on YouTube, he's an attorney out in California. We are working on the Antonio Sledge appeal pro bono in Atlanta. Okay. And so if you followed that trial, Sledge testified 2.5 years after he took his plea. DA Love in that case didn't like how he testified, so they filed a motion to revoke his probation literally 2 weeks later, and he got sentenced to 5 years because he didn't testify the way he was supposed to. There were errors in that case, so we filed an appeal because he had a void sentence. They sentenced him to too much time. Well, the judge agreed that he was sentenced to too much time, and she resentenced him on paper. Problem was, she didn't have him brought into court for this resentencing, so that was another error. Well, when we take it up to the appeals court, we waited 8 months. And you know what they told us? They remanded the case back down to the trial court to put findings of fact on the record. They was like, we need you to say in the record why you agreed that the sentence was void in the first place, so we can consider whether or not you were right. Like, we can't even determine if you're right if you don't tell us how you got to your decision. So when when we are speaking about findings on the record, you literally have to put in your order or on the record, so it's in the transcript, why you did certain things. So you can't just say, I'm closing the courtroom, time, place, and manner argument, safety. Like, you can't just say, you have to put your findings. You have to show that you considered reasonable alternatives, such as the overflow room or streaming an audio to the public. Like, it has to be in the order. So if that is the legal question, Bill Worski, when you jumped up to make your opening statement, why weren't you showing us how the findings were in the record? He just spent all of this time talking about, Judge, in order to understand how this happened, like what happened, how you failed to do what you were supposed to do. That's what it sounded like to me. You have to understand how we got here, Judge. It's because of, we were trying to keep him safe. Everybody was acting out of safety. It was just a lot of threats, Judge. So this is why things happen this way. This is why we had the paper docket. This is why we met in the judge's chambers. This is why we didn't have public hearings on the motions. We were doing it all to keep Karmelo safe. We were trying to make sure that he survived. Whatever. All I wrote was BS, no Waller findings. Sounds like the defense is winning that argument unless the judge feels like it wasn't raised in time. But there definitely are no Waller findings on the record.
Moving forward, there were how many witnesses to testify today?
Oh, wait a minute, because I want to finish going through his opening, because this is when he starts talking about you content creators. Bill got so petty during this opening that he actually just started calling out content creators and talking about them being instigators. So he says, let me see what the first time he says, this is the first time I've ever seen this where social media influencers, content creators, people who are just trying to monetize murder just to get clicks. And Judge, guess what? Some of them are even here today. And so, I mean, he ain't talking about me because I ain't had no drama, but he started to call out some of the other content creators. He dropped name Christopher King. He called him out as being someone who's been a problem. He mentioned Tiffany Billions as a content creator. He says that these people were painting false narratives, putting out improper information during the trial. So he just went on to say like that those people were creating all of this uproar and causing all of.
Called out the black content creators. Let's call a spade
that part, because there were other content creators that were not black that were making posts that were kind of causing some ruckus and stuff as well, and they didn't get mentioned today. So interesting. Let me see. So but he when I tell you all, he spent about 30 minutes talking about how concerned they were about Karmelo. Even after talking about the content creators, he comes back to say that's how concerned this court was about Karmelo Anthony. We knew Waller, but you don't know about these threats. Y'all see that statement? We knew about Waller, but Judge, you don't know about these threats. And it's because they didn't put Waller findings on the record, so he can't even point to us doing something right, and then he's back on the content creators. When I tell you Bill Worski was very petty today, he kept taking jabs at content creators and everything that didn't have anything to do with the motion for new trial.
He was deflecting. That's what he was doing.
Yeah, he was deflecting because he didn't have that legal argument.
You go to school, you go to class, and then you don't have your homework. So now you're talking about everything else other than but your homework that you turned in. Hopefully, this judge pick up on that.
Yep. He's saying like, Judge, you got to think about this. It was a stabbing at a track meet. The kids are witnesses. They're seeing all the threats, all the social media. They're getting scared. They don't want to testify. So like, we're trying to just keep everybody safe. It sounded almost like we may have not done it right, Judge, but here's a really good reason why we didn't. So don't hold it against us. So I left the court feeling at lunch break that the defense was winning on the motion for new trial on the public trial issue. Like I say, it's really going to come down to if the judge feels like the defense just waived that objection or not. Let's see. He really talked. I'm flipping pages and pages. He's still talking about the threats and keeping safe. He brings up, what did he say about Christopher King? Oh, so he says that, so if you go back to the public docket, there were about 9 subpoenas or so that the defense filed. That shows on that. It says subpoena. So they're saying that when those subpoenas were e-filed, that social media got a hold to him, and then they started doxing the people that they were subpoenaed, because some of them were child witnesses. And so that was another reason they kept things off of the docket going forward and hid pretrial hearings and had things off the record, because they saw that once social media got a hold to things, they would dox people and put the names out and all of that. They said that also Christopher King kept e-filing stuff. That's why they went to paper. And I'm like, dang, they called him a courtside disruptor is what they were calling Mr. Christopher King. I don't know him personally, but he was there today. He's actually in the courtroom as Bill Werski is talking crap about him. Okay.
Why is he filing? Why is he, if he's not an attorney in the case, why is he doing e-filing? On what?
Well, that was the thing they said. So Bill Werski says he mentions Christopher King's name. He says he's an attorney. I think he passed the bar. And then he said, I don't know if he passed the bar anywhere. I don't know if he's licensed to practice. I don't know if he really understands how being an attorney works. He was e-filing stuff. He e-filed a mandamus in this county, e-filed this. And I was like, oh, shots fired. Shots fired. But what wasn't fired is you're not focusing on the evidence that you didn't put in the Waller findings. And shout out to the lead attorney, Unc Alert. Sends 440 jewels. Shout out lead attorney. Thank you so much. Shout out to Grandbaby Apparel 9215 sends a $10 super chat, says thanks for the breakdown, sis. Thank you so much, Grady Baby Apparel, for tuning in. I know you from the A. Shout out to Lincoln Ward 85 sends a $5 super chat. If nothing's in writing, can the prosecution use the verbal agreement as justification defense of what happened? Well, so because nothing was in writing, and this is something else that the great question, Lincoln Ward 85. So the defense filed a motion on Monday to make an argument that Bill Werski could not advocate today and testify as a witness, right? Because they have Mike Howard. He's no longer the attorney. So he's given an affidavit. They can call him as a witness, and Karmelo has new advocates, where the state, they do have an appeals team, but Bill Werski wanted to continue arguing this motion. And so they're saying, we're questioning this gentleman's agreement that you're a witness to. So judge, don't allow him to be a witness and advocate. Let me tell you how Bill Werski got around that. Every time he stood up to speak, he testified while he was talking. Like in his opening statement, he spoke so much about the formation of this gentleman's agreement and how it went down. It's like he got in his testimony while he was talking. And I was so shocked that the defense wasn't objecting to this, because even when he was questioning witnesses, he was testifying. Finally, when we're like at 5 o'clock today, the defense starts objecting. They're like, Judge, we're giving him a lot of leeway objection, but he is testifying as he's talking. But it's like, nah, you didn't let him do it all day. He's got all this stuff into the record and into the judge's ears because he's been doing it all day long. So that is how he'd handle it. They didn't have to call a witness. He just ran his mouth a lot and put a lot of stuff on the record as he talked, as he asked questions. He just had a lot of off the cuff stuff to say today. Like, I'll get to it, but when they had the first witness on the stand, he's like, Judge, I really always thought Mr. Jackson was a great guy. Permission to shake the witness's hand, Judge. What? On one today. It was really weird.
Bill was trying to disarm the witness. That's what he was doing.
But it was a lot of that. It was just really weird. So during his opening, that's when he gets into all of this stuff about Karmelo, because they talk about the gentleman's agreement. So he just starts letting it out and saying what all they have against him. Oh, and he brought up, he said that the defendant's father has a relationship with Tiffany Billions, and he's afraid that discovery would leak out. So that's another reason they didn't want to put anything on the docket, because they brought up Tiffany Billions. I don't know this girl at all, but I think she's on TikTok or something. And so he said that somebody from her team, if you all recall, this incident occurred April 2nd, 25. Up until September of 25, Frisco ISD was allowing people to come in person to watch the original video of the incident from the track meet. Never heard of that before in my life, but it was happening. So they say that Tiffany Billions, this is what Bill Werski said. Tiffany Adams doesn't know this for fact, but they allege that one of her people went to the ISD to view, and I guess they had meta glasses on or possibly like a cell phone, and they took some video footage of this video and released it. And so they say when they saw that happen, they're like, oh, we can't trust anything. So they didn't want to e-file discovery or anything like that, because they just keep putting on the content creators instead of getting up there talking about how you did Waller findings. They dissed a lot of the content creators and blamed them as the reason for the state acting in secret and keeping all this stuff off the record. It's just, it was ridiculous. He talks about how I wrote BS. What did I put BS? Okay, so this gentleman's agreement, the state says that it never covered Karmelo Anthony not testifying, and that, I mean, Karmelo Anthony testifying. And, you know, I put BS next to this, and that was a lot of the back and forth when Mike Howard testified. And y'all, at one point, it sounded like Bill Worski was crying, okay? Because as he went back and forth with Mike Howard over this breakdown of this gentleman's agreement. It was really weird. I'm going to mock it and go over it in just a second. I'm just trying to, like, you know, kind of follow my notes, stay in order. Let's see. I was writing like every word. Bill Worski goes through how he would have never tried to purposely, you know, throw the agreement. He wanted Karmelo Anthony to testify because he, you know, felt like if he got him on the stand and testify and he was able to get in that some of that character evidence, then it would be a worse verdict than he ended up getting. I just wrote down he basically testified during his opening. He was just doing it the whole time. He basically just tried to get in statements that he would have put in on the stand. He did it from arguing in his opening. Let me see. He talked about provocation. Oh, he talked about the provocation jury instruction. He said it's a very rare issue. He says that they did the research and he feels like they handled that part correctly. So he didn't really go through and show the evidence that made out that third element. He just kind of talked about it in a general fashion. And he comes right back again. Judge, just got to understand about, you know, the devastating nature about what the state knew about Karmelo. Like, this is, so he admitted that he is the one that came up with the gentleman's agreement. He says that once they got all of the evidence, they knew the bad stuff that existed about Austin, but they knew what they had about Karmelo, and they knew they had leverage. So they used that leverage, reached out to Mike Howard and offered him a deal he could not refuse. And they even said it on the stand as Mike Howard testified today, like, we offered you a deal you couldn't refuse, right? That's why you took it. That's why you entered the gentleman's agreement, because you felt like you would lose if you didn't take that deal. And Mike Howard, is hard for him to say that today, right? Because he sees how it all played out. So hindsight, a Monday quarterbacking, hell no, it wasn't a good deal now. So it was hard for him to, like, well, I mean, had it gone the way we thought it was going to go, it would have been a good deal. But no, it really came back to bite us in the ass. So I can't really, you know, say it was a good deal, but that's how the deal came about. The state, and that's how it is in these cases. Like, it's a lot of times that people want to go to trial but we just don't have the evidence, or the evidence is too stacked up against you that we won't win if we do. So as your attorney, will advise you to do something different if we know, you know, what's going on. But let me tell you this part. So during one of the breaks, I stayed with Karmelo's family, and I was so shocked. The stuff that I'm going to tell y'all. Wi-Fi, what's going on? Oh, I'm sorry, y'all. I'm in a hotel. Wi-Fi is tripping. Okay. So today was their first time hearing it. Unbelievable. Because, I mean, your attorneys had this information. Why didn't they share it? My heart broke for them, because they didn't know anything about this criminal justice system. This was the first time they had ever dealt with it. And you could just see they were so dependent upon who they were hiring and the people that were coming into their lives to kind of educate them. It is so sad that they just were kind of clueless. I even asked the mom, I was like, when did you find out about this gentleman's agreement? 2 weeks before trial. What? And how was it explained? Mom, as character evidence. They don't understand what character evidence is. They don't really understand the intricacies of this agreement. my heart breaks for them. Okay. So in this whole case is an example of you put your best foot forward on the first go out. It's very hard to climb out of a hole. And I'm seeing that with this YSL case. I don't do appeals a lot, so this is my first one. So I'm seeing you can be right, but it's very hard to go back and right a wrong that's occurred after the fact. So all of this energy should have been placed on this case from day one, because you just don't know how that second chance is going to go. Because I'm saying all of this, I say it's a good argument for the public trial, but Judge Chitty could listen to it and say, yeah, no, the defense will kind of feel like you went along with everything on the first round, so you don't get to raise this issue. And Karmelo's back to prison for the rest of the sentence. So, or until, he takes another appeal. But I'm just saying it's really hard to undo things. So you got to spend that money, put all of your energy into getting great attorneys on the front end so that you don't have an attorney that's making a gentleman's agreement that they don't even put in writing on your murder case when you're facing life in prison. Let's see. All right. So we take a break after Bill Worski does his opening. It's like a 10, 15-minute break. And the first person that the defense calls to testify is Derek Jackson. That is his first name, right? Yes, Mr. Jackson. And I told you he was the first public information officer that was appointed to the Karmelo Anthony case when it first started. So he was a Collin County employee. And you hear me saying was, Mr. Jackson got in trouble and got fired during this case. And that was kind of what came up today. And the purpose of having him up there is just kind of talk about the conversations that they had leading up to the trial on the overflow room, or the live feed, and how they set all that up and determining who was going to come into the courtroom. Like, that is the purpose of his testimony. And just to show how he was treated and how the judge treated him unfairly, to show like how Judge Roach was behaving in this case. Okay. So Jackson, he's called up there to testify. They asked him, what his job was, and it was to manage media requests for this case. And they talk about just all of the things he had to develop, because mind you, he was on this case from the beginning till they fired him May 13th. So he's developing the Google form that media is filling out. They're having these meetings with the different county departments, so they can determine if they're going to use the overflow room, how to make the overflow room work. They had to get all this feed stuff together. They say when they first started doing the feed, they could just feed a static feed. They couldn't figure out how to get the exhibits to show the witness testifying and the attorney all at the same time. So they had to work on getting that together. So this is the kind of stuff that he worked on. He's in communication with the judge and communication with the DA's office, administrators, to decide what media they were going to let in, how things was going to be. He testified about, I think it was like a couple of weeks before the trial, Judge Roach let in local media to get B-roll footage of the courtroom, because cameras weren't going to be allowed inside, but he wanted people to be able to have some footage, so as they would give news recaps, they could share this to the world, and people could kind of see where everything is happening, right? They had a sketch artist, and then media was allowed to get this B-roll footage. And the B-roll footage, I would say, they said that Judge Roach came to him like on a Thursday afternoon and said, yeah, I don't have court tomorrow, so you can let the media know they can come inside and get some footage from 10 to 2. And so he's like, he had less than 24 hours to notify people. So he just notified the local media stations that they could come in and do this. And so basically that was his testimony. And he talked about how things went left. So remember, I told you how they were keeping everything secret. July 28th of 2025, Judge Roach put in place what's called a gag order. So the gag order stated that you couldn't tell any, let me see if I can pull it up. You couldn't release any information about the trial. Nobody could, talk about anything about the case. And at the bottom of this gag order, let's see if I can pull it so you can see. It talks about the times that you could discuss something about the case. Let me see if I can actually find a copy of the order. And so what happens May, I believe the 6th, the AP, Associated Press, emails the public information officer asking for an update of the hearing schedule. So, and I'm trying to see if I can find this gag order. Trying to see if I can show y'all, but I don't know if I can put my hands on it quick enough. All right, so the gag order at the bottom gave exceptions to it and said you could give out hearing schedules, blah blah, and something else. So when Mr. Jackson gets an email from AP asking for the schedule for trial, he's like, oh yeah, the schedule came out, let me send it to him. So he emails it because in his mind it's falling under the exception of hearings, right? It's a hearing coming up. So he gives AP the date. Shortly after AP asked for it, Christopher King, content creator, emails asking for the schedule as well. He says he doesn't think anything of it. He thinks I can give it to one media, I can give it to the next media. It's just the schedules, the hearing dates. So he copies and pastes the emails that he sent to the AP. He sends it to Christopher King. Christopher King puts it out. It goes viral. Everyone is livid. So come Monday morning, well, he's getting blown up all weekend on his phone. He says it was Mother's Day weekend. So he's like, I don't know what's going on. Let me cut this phone off, because he was getting texts from like media like, oh my God, when's the trial schedule? We heard about a trial. He's like, I don't know what's going on, but don't listen to social media. We'll let you know everything. But he says the weekend. So he's like, I'm cutting my phone off. Monday morning is when he gets a call from Bill Worski. He kind of goes off on him, which is a regular occurrence, is a joke around there that they joked about in the courtroom. But not only that, the judge is livid as well. So he's told to get his bosses to call Bill Worski, and then he is called into a meeting with the judge. And I can't remember what day that occurs, but it's that following week. So he has a meeting with the judge. I want to say it was on Thursday. And he says he comes to the courthouse. He's thinking, okay, I'm in trouble. I messed up. But, hey, what is it? It's the hearing date. Like, I don't really understand how big a deal it is. And I think I'm going to have an opportunity to explain what happened. So he goes into the judge's chamber. He has to wait like 45 minutes for the judge to get ready to meet with him. Judge is there. Two of his supervisors are there. And when he walked in with the supervisors, one of them was carrying a folder, but he didn't think anything of it at the time. So he says he sits down. He thinks he's going to get questions and a chance to give an answer. But no, he said Judge Roach reeled him, fussed at him for 6 minutes straight. Never took a break, didn't ask him, give him a chance to explain anything. And so he went off on him for about 6 minutes and then says, you know what I can do? I should hold you in contempt. I can hold you in contempt for 6 months. This is what Judge Roach tells this employee. So he says immediately he starts, not immediately, but he's like, I never considered myself to be a crier, but I started crying because I'm thinking like, oh my God, am I going to leave today? Am I going to go back home? What am I going to tell my family? I've never been to jail before. He could hold me for 6 months. Like he believed the judge could do what he's saying he was going to do. So he's having a visible reaction. He's crying about this because he's thinking about, I've never been to jail before. Like, what? I just thought this was like a little error. Oops, my bad. Move on. I apologize. Maybe a write-up. But he's like, you're threatening me for 6 months in jail? He said the judge was silent after he said it. So like, I could lock you up, hold you in contempt for 6 months. And then it's just quiet. So during this quiet 2 minutes, he's crying. After about 2 minutes, the judge says, I'm not going to do that. It's like, what? After this man has sat here and bawled his eyes out, thinking he's about to go to jail, the judge is like, I'm not going to lock you up. You made a mistake, blah, 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 blah. They end the meeting. But as he walks out the meeting, his supervisor pulls that manila folder out, takes the document out, and he's fired on the spot. So they terminate him on May 13th, and he's released. So Russell Wilson kind of goes back through and wants him to really talk about how he felt when Judge Roach told him this, because it's more of the showing how all of these meetings happened just in the judge's office. The defense attorney was never there. Then the judge doesn't follow due process, doesn't give you a notice for a hearing. He just tells you, I'm going to hold you in contempt, threatens you with 6 months, then tells you psych, and then you walk out the door and get fired. It was just putting things on the record to show like how shady and how things were going, or how the judge was handling everything about this case, was what I got the point of his testimony. And he talked about also too how they came up with the overflow room and how they were working to get that, just to show also that the judge had alternatives that he could have put in place and that he didn't consider or put why he wasn't using these alternatives on the record. He also was asking, like, did you get a reason as to why they weren't going to do the overflow room for testimony? Like, was it about these threats and everything that Bill Worski just jumped up and talked about? And he's like, no, it was just more so a limitation of us being able to do the feed. Like, we couldn't figure out how to, we could just have a static feed. We couldn't figure out how to do all the moving parts. Today, as they live stream to the ceremonial room, they use Zoom. So that's how they opened up Zoom in our room, and they were showing it there. But we got a message during the hearing that they couldn't really hear Russell Wilson, so he had to, get closer to the mic. So it wasn't the best viewing experience in there, but they were able to, kind of see what was going on. Let's see. All right, so he goes through all of that. He's cross-examining. So when Bill Worski starts cross-examining him, it's just like the whole, I always thought you were a great person. You always wanted to help everyone. I think that's kind of how you got it caught up in your situation. That's the kind of conversation that Bill Worski, how he's talking to him. And he's just like, I told you, he asked the judge, like, Judge, I always thought Mr. Jackson was a great guy. You mind if I shake his hand? If I shake the witness's hand? Like, he was just doing, it just was really weird. Like, distracting things, right? Like, let's get to the point. Like, we're talking about these Waller findings. Did y'all do that? Did you do it? Stay focused, Bill. He was all over the place. It just kind of was really weird. He even talked about, he said, like, I didn't know you were going to get fired. I didn't know that's how it was going to go. And so when Russell Wilson got back up, he's like, well, Bill, Mr. Worski just shook your hand and said all these great things about you. Did he ever call to the judge or to your boss and help you get your job back? And he's like, yeah, no, I never heard anything from anybody after I got walked out. It's like, yeah, right. Bill, stop putting on. He just was doing a lot today because I don't think he had the legal argument to come back on those Waller findings. So the public information officer that is in place now, Russell Schaefer, that was Mr. Jackson's boss at the time that the incident happened. I'm not sure if he's the one that fired him, but he was his superior when that occurred. I went through all of that. All right. So make sure I covered everything. Oh, so then Russell Wilson pulls up the gag order. And I remember, I wish I had it right here, but at the bottom, it talks about the hearings. He said, did you consider the trial to be a hearing? He said, yeah, that's why I didn't think I was doing anything wrong, because it said that we could disseminate information about hearings. And Bill Worski interrupts, it's not his turn. He says, Judge, just want to be clear, like, we're talking about trial schedule and that references hearings. Russell Wilson's like, Judge, a trial is a hearing. Like, it's one and the same. So, like, Bill Worski was giving really weird vibes. Like, it's not even your time. Like, wait and talk about that when it's your time to talk. Let's see. So when Bill gets him to cross-examine, he, talks about his job. And so he takes another shot at the content creators. And so he says, like, when you got this job, you didn't know anything about the court system, right? He's like, no, he had a media background. So this is his first job in the criminal justice system. So he said, you thought you were going to be hired to kind of like, just communicate between the media and the court, right? He's like, yeah, just to kind of, set up who's going to come into the hearing. So Bill Worski said, you didn't think you'd be getting requests from, independent journalists like content creators, did you? And he's like, no, I didn't. And he says, you didn't think you were going to be getting messages from North Carolina Beat, did you? And he's like, no. And then he says, did you know he'd been arrested 19 times for calling in bomb threats? It's like, Bill, what? Wow. Like, where did that come from? That has literally nothing to do with this motion for new trial. Why are you taking shots at the content creators in the room? Okay, so that's the third content creator second person that was in the room today that he was taking shots at. I was like, oh my God. And the things that he was bringing up happened over 10 years ago. Okay, it just didn't have a point, but Mr. Worski was taking shots at everybody today. I was like, good thing I didn't come to the original trial. What he was going to dig up on me? Because he was taking shots. And, he also said, told the guy when he's on the stand, he was like, the DA, we didn't have a public information officer. So you filtered a lot of conversations and calls that we should have been handling. You had to handle that. He's like, yeah, really apologize about that. I'll make sure the commission knows. It just was really, I don't know. It was really weird. He talked about Lisa Braxton. Remember, I mentioned Lisa Braxton being this appeals person in their office. And so her name came up in the issue of Waller. They were trying to ask Mr. Jackson about Waller. Y'all, he's not a lawyer. He doesn't know anything about the whole Waller. He's like, I don't know anything about that. He said, I know y'all had somebody in the room that was trying to look at precedent, but I don't know anything about that. So it wasn't really relevant to that. Just trying to make sure I cover everything. Oh, and then did you think? Oh, and then okay, so like I told y'all, Russell Wilson asked Mr. Jackson, did Bill Worski say all these great things about you? Did he ever call your boss to help you get your job back? He's like, no. He's like, do you think he knew that you were going to get fired? Here go Bill. I didn't know. Nobody was talking to you, Mr. Worski. Like, he just was making outbursts all day. It's just, it's almost like, and when Mike Howard was up there, you'll hear how he was. It's about his reputation. So he feels like his reputation has been attacked about the gentleman's agreement, about how this case was done, people making it seem like he tried to railroad Karmelo. And so that was a lot of things that he communicated today. Like, we cared about him. We tried to keep him safe. We tried to make sure his life was saved. These are the reason we did things. No, I didn't know he was going to get fired. He just kept blurting out things, and it was really important to him to clear his name and his reputation today. All right, so at this point, so the defense talks about their exhibits. It was 1 through 47. The state didn't have an objection, and then we went to lunch. When we come back from lunch, that's when they call Mike Howard. Now, mind you, y'all, this day was very long, and hopefully we get through the witnesses tomorrow, because they're supposed to have 4 witnesses, is what the defense announced today, that they have 4 witnesses of people who came to the trial and weren't let in. And then they were going to call Toby Shook tomorrow. And we only got through 2 witnesses today. So I really hope things kind of speed up tomorrow, because the law says that this motion has to be decided by August 23rd. Since that's a Sunday, then August 24th is the deadline, but they need to wrap it up. Okay, so hopefully tomorrow goes a little faster, because we came back from lunch at 1:30. Court probably started about 1:45, and all we got through was Mike Howard from 1:45 until almost 6 o'clock. Okay, so the defense calls Mike Howard. Of course, everybody's like, oh, everybody gets to the end of the seat. They're leaning forward, because this is Karmelo Anthony's original defense attorney. Everybody wants to hear from him. As he said while he testified, like, my reputation has been dragged through the mud. Yes, because everybody listened to the commentators telling us about the trial that were there in person, and we felt like, where was the defense, Mike Howard? What happened? You didn't cross witnesses about their inconsistent prior statements. Karmelo didn't testify. You didn't put in any bad things about why didn't any of that happen? And we learned it's because of this gentleman's agreement. So Mike Howard gets on the stand, and when he walks in, I'm like, oh, got the same blue suit and white top that Karmelo and Russell Wilson had on. So I don't know if it was planned, but Russell Wilson, Karmelo Anthony, and Mike Howard all had on blue suits, white tops. He introduces himself, puts his name on a record, and Russell Wilson starts questioning him. He says, you're the lead trial counsel from the first trial. He says, yes. He says, have you ever met the judge before? Because Judge Chitty is brought in from Collin County. I don't even know where that is in relation to where we are, but I know it's hours away. So he said, no, I've never met him before. I've never been before him. He said he started practicing in 2004. So he hasn't been practicing much longer than I have, just a year. He grew up in Dallas. He went to Texas Tech. He went to SMU for law school. He started out at Legal Aid at an organization in Texas that did indigent I'm talking all day, defense on civil cases. So he worked a lot with the homeless and legal vets. He says after about a year, he knew that civil work wasn't for him. So he went to the Dallas County Public Defender's Office. He was there for like 4.5 years doing misdemeanors, and then misdemeanors all the way up to felonies. He left in 2009 and went into private practice, and he's 100% criminal defense private practice out of the DFW area. He has a partner that works for him, an associate, Tasha Gupta. She started with him October 2025. She interned with him back when she was in law school at SMU as well. And he has several paralegals. His mentor still works at SMU. So that's how, his associate comes from SMU and interns. He was retained Friday before the original bond reduction hearing. So he got hired a week before Karmelo's bond got reduced. So he's been on the case from pretty much the start. Let's see. Karmelo's previous attorneys filed the motion for bond, and then he came in and argued it, got a bond, and got out. He had never had a case with Bill Werski directly, but he had heard about Bill Werski being a very, prominent and top attorney, criminal attorney in Dallas County or in Texas. He had cases before with the other DA who tried the case, and that was Dewey Mitchell. And then because Bill Werski has this thing where he just like tells war stories and just says stuff or whatever, Russell Wilson was like, yeah, does he have a history of telling war stories? And he's like, yeah, they laugh about that. At some point, Judge Roach, so they start talking about how they got to this secret docket, and he just talks about, how they had the conversations and how he doesn't recall, who proposed to handle things like that. But basically, pretrial hearings and everything were conducted off the record. He said the motions were drafted, given to the judge, but they were never filed into the record. Karmelo Anthony was never present for any of these off the record discussions about pretrial hearings. He never showed up. They met, he says it was 12 or more times that they had these off the record pretrial hearings. So we're talking about 12 times that they met, and they would either meet in person, the defense and the state would talk on the phone, or they would have a phone call with the judge to make these decisions. I've been practicing 20 years, and I will say it's kind of lax like that in like family law cases, right? And I saw the lead attorney in the chat earlier. When you're in family practice, we'll do some phone conferences on cases like that, but never in a criminal case have I had phone calls and I wish some stuff I don't have to go to court for. It could be done Zoom and a phone call, but no, every time I have to, I have a hearing or I have a motion hearing Monday in a case about character evidence coming in. So we actually having a hearing. We don't just go to back in chambers and say, Judge, what are we going to do here? So, but as Bill Werski said, this is how they do things in Texas. So I don't know, if this happens in every case or what, but that's how he put it. And that's what happened in this case. But like I said, you all, the biggest problem with that is now you got to appeal. So when I go pull the record, if you did everything off the record and I want to challenge something, there's no record for the appeals court to review and challenge, which is why when the defense filed the motion for new trial, they had so many affidavits attached, because whatever you submit as an affidavit or an exhibit to this motion for new trial now becomes part of the record. So now when the appeal court wants to review something, they have Mike Howard's record, his affidavit stating what occurred with the gentleman's agreement. So now it's part of the record, although a record wasn't completed or made during the trial, which is crazy. Going through, let's see. They asked him about this, the proposed order with the Waller findings, and he talks about Lisa Braxton sending him this order. And so then Russell Wilson pulls the order up on the screen, and when it talks about, remember I told you how Bill Werski jumped up and 20 minutes of his opening statement was talking about how they were trying to keep Karmelo safe and they had all these threats. Well, guess what was in the order? Not that. That wasn't the reason that was placed in the order, that the proposed order. It didn't say anything about the threats and the safety. And Russell Wilson asked Mike Howard about that. Did you ever hear is that being the reason that you couldn't do the feed? And he said, no, we just couldn't figure out how to do, a feed and show everyone. Never about we weren't doing the feed because of safety. So, that was kind of telling, right? Because if that is the reason you did something, you would think that that reasoning would be in the proposed order. But guess what? The order doesn't matter because it never got signed by either party, never got signed by the judge, and never got filed a part of the record because they were on that secret stuff. They weren't paying attention because, and then they're like, well, we were holding it to the end of the trial, and Bill Worski tries to act like it never got signed because Karmelo got a new attorney. No, it never got signed because the judge was on TV doing the interview versus cleaning up the case. Okay, truth be told. All right, so I missed some super chats, so let me take a pause and go through those. Give me 1 second. Where did I stop off? Okay, so shout out to Tyrone Phillips, and you were in the chat yesterday, so thank you for coming back. 9872 sends 2 jewels. Thank you so much. Nini41 becomes a new YouTube member. Thank you so much, Nini. Shout out and welcome to the channel. Lisa J. Snipe sends 350 jewels, sends a heart. Thank you so much, sis. What do we got next? $2 super chat from Lady J 5682. She says, thanks for this excellent commentary. You're so welcome. And I was so tired when I left court. I told Dennis, I was like, give me 10 minutes. I don't want to talk. It's hot. I'm tired. But as soon as I got back, I was like, let me set up the live. I want to tell everybody what happened. So thank you all so much for tuning in. Teresa Wright 828 sends 650 jewels. And shout out Teresa. You are you I'm gonna go to my Cash App because I did get some Cash Apps after the live last night, and just during the day y'all have been sending things, so I greatly appreciate that. So I'm going to go through those as well. Where did I stop at? Sorry, where's Teresa? Okay, next we have Tatiana 2363 sends 10 jewels, says hiding, come out the bushes, sis. Ayana I5W sends a $20 super chat. Shout out Ayana, thank you so much. She says, how credible is Worski's evidence concerning Melo's alleged text message? Did they display call messages showing what he said? Where's the proof? Example, notified school officials, violent history. Okay, great question, Ayana. So yes, Russell Wilson did put up those things actually during Mike Howard's testimony. So we're going to go over. So they did. And like I say, Bill Worski, as he's saying it pre-lunch, I'm like, oh, guys, that sounds so bad. Now, the whole message, the text message, it was a real text message off of Karmelo's phone that he sent to his girlfriend that said, I want to stab, when I stab somebody, I'm going to lick the blood off the knife. That's what he said. I don't know what their backstory was and what was going on and led that, but they were real text messages. But everything that they were going to use against Karmelo was on his phone. But Austin them had way more stuff to me. And I'm going to go through it and you all can, be the judge of it. It's coming up. But they had a lot more against them, I feel like, on their side. But the problem with it is, with them being the victim, you have to have a hearing on both sides to determine what all is going to come in. But yeah, so they did actually display the text messages that that Bill Worski said existed. They put up the picture with Karmelo with a weapon. They showed that it actually does exist. Now, there was nothing about a school official or a violent history. So when they said it's violent history, they were actually talking about Karmelo's 2 text messages where he talked about getting in a fight. And they say that his parents sent him to some school at LSU, some kind of program that was for wayward youth. But every time they said that, Karmelo's parents 2 rows in front of me were like, what? Like that's not it. So I don't know if it was like a football camp or something that had a different name that, because it's the state's, it's his argument. So he's going to kind of color it to fit his theory of things. So I don't know what the program was. He couldn't remember the name of it, but Karmelo's parents shook their heads adamantly like, that's not true, every time he brought that up. So thank you so much, Ayana. Great question. And thank you so much for the $20 super chat. TKO every time 19 sends a $5 super chat, says, did Howard appear as meek in person as he comes across in print? I don't see how he can fight to defend anyone. He seems subservient to prosecution. Good question and great point. So, because it was some times when I kind of felt that way today, where they were asking him, like Bill Worski's asking, do you think I lied to you? Do you really think that I lied to you and didn't want Karmelo to testify? And so instead of saying, hell yeah, I think you lied, because how did you not? He's like, I don't really want to go there all the way, but hindsight, I've been thinking, it's like, come on, Mike, shit, say it. Yes, you got played. Say it. Like, it is some BS. So, to your question and what came up on the stand and how Mike Howard was asking, this gentleman's agreement comes up and it blows up when the state says, one, they felt like Mike Howard opened the door on opening when he said that Karmelo was in the chess club. Mike Howard was like, first off, I didn't say he was in the chess club. I said he played chess. Behind, I said he had a job. He gets straight A's. He plays chess. Like, I'm just running down, giving people a brief background of who Karmelo was. And so, the judge instantly said that doesn't open the door, but Bill Worski doubled down and kept saying, you open the door, you open the door, you open the door. And even today, Bill Worski said, I might have been a little heated. I might have been a little hot-headed, because even when the judge saying, no, they didn't, he doubled down on that point. And then he says, oh, yeah, and this agreement never covered Carmelo Anthony testifying. And that is the question that was bullshit. And I wrote down in my paper, and Mike Howard kept like straddling the fence. It's like, no, Mike Howard, say it. Tell him it's bullshit. Because if the only evidence that you had against Carmelo that was this extrinsic evidence was some camp he went to and text messages from his phone, how else were you going to get the text messages in? Like, who else were you going to question about the text messages? If he did, you had to call his girlfriend, because it was a conversation between girlfriend. And then the other two messages about fights was he was just telling stories about things that happened in the past, right? So who else were you going to get that information through? The agreement said anybody under the tent can testify to the facts and everything that happened under the tent. So if Carmelo's under the tent, the defense took the position of he's covered by the agreement because Carmelo's one of the people under the tent. So when you say you want to try it clean and we can only speak about what was under the tent, he qualifies. And Bill Worski says, no, we never contemplated the defendant testifying. That statement is bullshit because, one, you had cell phone messages. How were you going to get them in but through Carmelo testifying and open up character? And then he's a person under the tent. And thirdly, Bill Worski started talking about this mentor of his and how the theory is anytime it's self-defense, the defendant has to testify. You've been practicing longer than Mike Howard. Most self-defense cases, the defendant has to testify. Why didn't you all contemplating Carmelo? Like, it is BS. So I agree with you. Mike Howard, he is like, because he still has to practice with these people. Like, he's got other cases right now. He's got other defendants. He's going to have to come in his courtroom. He's going to have to work with Bill Worski again on the case. Like, it's like he didn't want to go ahead and say that. And during this exchange, we all in the courtroom thought Bill Worski was crying because his point was like, do you really think I didn't want Carmelo to testify? Because Mike Howard's put forth a position that Bill Worski, reneged on the deal. And he's like, and so he asked him twice. And the third time, his voice changes and is shaking. He's like, did you really think I didn't want Carmelo to testify? And everybody looked up. I was like, is he crying? And his like hands shaking. He's holding like, so he wasn't crying, but it sounded like it. And he was like, this matters. My reputation matters. Did you really think I didn't want Carmelo to testify? And Mike Howard just is like, I don't know what was in your heart. I just know how everything happened and how it played out. Like, he couldn't go ahead and say it at this point. I'm saying it like, Mike Howard, we're all like wondering why you entered this deal. You got played. So call him on it. Call him. And he didn't go there. But Bill Worski was he really wanted to make sure that his reputation was intact and in good standing at the end of this hearing. So it really bothered him that Mike Howard thought that, he was playing funny business with this agreement. He was very bothered. Like, anybody in the courtroom will tell you, we thought that he was crying. His voice was shaking and everything. Let's see. All right. So, because I want to get to all of the bad stuff about Austin. And I took notes on that. So let me just make sure I covered everything. Okay, so then another part that, came up was Mike was saying that there was discussions about this public trial because, you know, the defense has to show that they didn't waive this argument. So they were asking him, like, did you agree to go along with this? And he's like, you know, there were discussions, but I never waived Karmelo's right to a public trial, and things happened beyond the order. So remember, the order came out, 9 legacy media, 15 family members per side, 27 members for the public. But how that was administered was all by Steve's, I think it's Scholler, something like that, the last public information officer that was in place at the trial. He was the one emailing people and actually saying how the judge's order was going to, be managed, how it was going to actually, you know, be put into effect. And so Mike Howard was like, wow, I know the judge issued this amended order. I didn't know, we're in the trial, so I don't have any knowledge of who's actually being kept out. The fact that grandma can't come in because the family isn't getting all 15 seats. They only got 8, you know, once the trial actually started. And he's not, you know, cognizant of the fact, like, they got overflow room for jury selection and took it away for trial. He's like, I can't pay attention to all of that. I'm focused on the trial. So while I may have waived our original decision about the restrictions, I wasn't aware of all of the restrictions. And that's what they're going to try to get into tomorrow with these witnesses that they subpoenaed that showed up and couldn't get in. That's what all of that testimony is going to go further into tomorrow, so that the defense can show, wow, yeah, we went along with things at the trial. There were things that happened that we didn't know about that we couldn't object to. So, Judge, we haven't waived this objection, because they got a really good argument, and they're going to win it if they can show that they didn't waive this objection during the trial. All right, so let's get to the good juicy part, how everything that came out about Austin, because my mouth was on the floor of everything that came out. And when you hear all of it, you're gonna be like, why did you do this agreement again? So let me just go through. Okay, so when they started talking about this, how they handled it, remember I told you there are no filings actually stamped, where there was a motion in limine prepared by the defense to show these are what was the title? Because I wrote down the title of it. It was Anthony's motion in limine regarding the admissibility of pertinent character trait evidence under the ambiguous aggressor rule, and evidence under Texas Code, whatever. And then it's a multiple page document that is then listing what exactly Austin and Hunter, they found on them, the dirt that they were able to dig up.
I had to come back for this one.
I know, I saw you jumped up as soon as I said it. So they, and this is when he talks about how Mike Howard talks about how the gentleman's agreement was joked about, you know, during some of because remember I told you it was about 12 of these off the record pretrial hearings. So in the first few, Bill Werski is dropping the idea of this gentleman's agreement, but it's kind of like in a jokey fashion. They're like, why would we agree to that? And then when they get more into the case and they see all the stuff that they have against Karmelo in these text messages and pictures, they're like, oh, well, maybe run that back. Maybe I do want that deal, right? And so they had evidence that they were going to enter or try to enter against Austin and Karmelo. And let me just say, while the state shows that they have these text messages and all of this, and I'm going to go through what Austin and Hunter had, they both still would have had to have evidentiary hearings before the judge for him to determine if these things were going to still come in. So just because these things existed didn't mean they were going to automatically come in against Karmelo or against Austin and Hunter, but they existed. Okay, so this is what all that's about. So so this is some of the stuff. So one thing was, there was a text message that was said, KKK, kill all Black people. No, this is their graffiti. So from the graffiti arrest that Austin and Hunter had, now this is something that happened, I think it was like 2019. It was years ago. And they were younger when it occurred. And so they didn't go to, like, you know, adult jail because they were under 17 when this occurred. But they spray painted KKK, kill all Black people, heal Hitler, and N-word. And there was when they first got this evidence, it was just a report of it happening. But they're like, oh, give us the body cam, give us pictures of what actually was done. They asked for it. The state went and got it and gave it to them. So now they have these pictures of the graffiti. The
No,
boys
they said hi Hitler, hi Hitler.
Hi Hitler. Oh, okay. I was like, okay, thank you. Okay. And they they got arrested for this. And there was somebody else that was there too, was another young man that was with them, Logan, and he drew the picture of a penis, and they did all the racial stuff. So when the police come, they're like, Logan's like, look, we did this, but the brothers, they took it way further with the racial stuff. I didn't have anything to do with the racial stuff. And so that came from Hunter and Austin. And so their parents got involved, and mom was like, kind of like, I want them punished so that, we're not coming back in 5 years and they're not, they still being bad kind of thing. And we see what happened. They continue to kind of be menaces. And so that was the first thing they talked about. Austin messaged about killing. Oh, okay. So there was a text exchange where somebody was telling Austin that some people were at another track meet or something. Tell them about, and a student behind them was sitting behind them in the bleachers. And I guess they were talking junk about him, whatever. And Austin texted, you should kill that MF. Austin and Hunter received 12 months of probation from the graffiti. Let me see who else. Logan, the guy who was spray painting with them. So fast forward a few years later, Logan says to one of them in a text, one Edgar behind on the bench was talking wild. So Edgar is a slur for a Hispanic boy. I've never heard that before. And so Austin then says, that's what that kill that MF is too. So basically, this Hispanic boy was sitting behind them talking junk on the bleacher, and then Austin's response was kill that. So it's similar to the Karmelo Anthony situation, right? Because they said Karmelo Anthony was talking junk, making statements about them or something, and so they felt offended, and so that's or under the tent, so they feel like they have to do something. So they were going to try to get that in to show a correlation between the Karmelo Anthony case. There was another incident when Hunter messaged about jumping kids from Independence, it's another school, track team at a prior meet. Hunter said that these shitty indie kids talking, Hunter says, let's jump them. So it's like whenever somebody's talking mess or they feel like somebody's doing something to disrespect them, they want to jump them. They want to fight them.
That right there. That has been the conversation throughout the trial, that there were both the brothers around Karmelo.
Mm-hmm.
And it does appear, based on these text messages, that they're lockstep on dealing with whatever issues they have with anyone.
Mm-hmm.
They got caught doing racist graffiti.
Mm-hmm.
They allegedly collaborated on other incidents, and this only proves that when the father said what he said post conviction, the kids got it from either him or his mother. And I haven't heard the mother speak like that. So so the apple don't fall too far from the tree.
Not at all. And I got some more, and it gets worse. So April 1st, 25, the day before this incident, Hunter is actually banned from classroom because he kept kicking the door, and the teacher got mad. Hunter says, no, I'm not talking to her. F that weak ass teacher. So they don't respect authority at all. March 22nd, 25, Austin and other shot putter throwers, they got in trouble for leaving early. We heard about this during the trial, right? Remember, if you don't recall, Austin had actually been kicked off the track team by the coach on March 22nd, 2025, because he got upset that all the shot putters did their shot putting throws, and then they left. They didn't stay around for the rest of the team to finish the track meet, so they weren't showing, brotherhood. So he kicked them off the track team. Well, they were just reinstated literally the day that this incident occurred, the day before. So he tells them, and that's why the coach sent Austin that message that morning that says, I need you to be a leader. I got to go, help run the track meet. So come set up early, help set up the tent. I need you boys to be a leader. He was trying to, so he says the suspension was to scare them. And then he was bringing them back in to teach them leadership and all of that kind of crap the day that this incident occurred. So there's a lot of things going on this day, right? Because we had the state member told us Karmelo got broken up with. He's going through this little thing with his girlfriend. So he's got all his aggression and stuff. Austin was kicked off the team. The coach is trying to bring him back in, but it's put him in charge. Get there early, set up the tent, man the tent. So he feels like he's in charge. So it was just, it's just all of this stuff is going on, both of them, the day that this occurs. Let me see. They said on Austin's phone, they found that he followed 300 different fight-related channel accounts. So 300 accounts that he follows on his Instagram are about fights. So like fighting, all of this stuff, this is part of his life, part of his nature. February 3rd, 2025, Austin used the N-word and said F Edwin Para. And Hunter said, we have 2 N-words. You want to punt? So if you all recall from the trial, Edwin Para is the individual that Karmelo Anthony went under the tent to talk to, right? This is somebody he knew and had hung out with in the past. It was his girlfriend's like cousin or friend or play cousin or something like that. And so to hear that 2 months before this happened, and at the trial, Edwin Para tried to act like he didn't know Karmelo Anthony, right? They tried to like take the side of Austin and Hunter, and he acted like, oh, I know of him, but we ain't all that cool. And the defense attorney had to pull up all of these pictures at the grandmama's house with them, playing like boys and sitting next to each other and smiling in the picture and all of that stuff, right? Because Edwin tried to downplay it. And to know that February 3rd, the people that you're trying to protect, and a lot that you don't know Karmelo, they were talking about you and calling you the N-word. Like, this is how they thought about you when you run around. They're like, oh, we got 2 N-words. You want to punt? What does that mean? You're going to kick him? Like, ridiculous. What else? Oh, it gets worse. They went all the way up to like number 37 or 38 of the acts that they had against Austin. Edwin Para turned his back on Melo and acted like he didn't know Karmelo Anthony. But did he know, what they were saying about him? Number 8 was Austin was using the N-word on April 1st, 25. October 23rd, Austin bullied Tehran, a Black student in class, and used racial slurs, and says the coach wasn't going to do anything because he was a varsity starter. So they've been getting away with their actions for a very long time. And it came up that Austin and Hunter used the N-word a lot. And Mike Howard says, and it wasn't always, the playful N-word with the A. They used the hard R a lot of times. That's what was testified to. Hunter threatened to hit cheerleaders, and the cheerleaders saying that they are scared of Hunter and Austin. And that was that whole email conversation that came up during the trial, that they parents of the cheerleaders were emailing the school telling them that Hunter and Austin were bullying the cheerleaders. They were out at at an eatery or something all together, probably after a game that you do in college. Everybody goes somewhere after the game, and Hunter called one of the cheerleaders a fat bitch. Hunter he was put on a stay away plan from another student, a Black student in school. So he was having issues with this student. Yeah, he was messing with this student. They put him on a stay away plan at school. 2018, May, Austin, who was 10 at the time, and Hunter, they were arrested for assault on a female student. The female student mistakenly touched Austin's face, and they both pushed her down forcefully. So this is at 10 years old. And this incident occurred, 17, 18. So it's so many things in between. Like the behavior escalated. May 7th, 24, Austin and Hunter assaulted another person a female for blowing vape smoke in Austin's face. Vape smoke. they assaulted her. Austin and Hunter kicked out of a football game for wanting to beat up kids, said the kids were talking crazy. They always feel like they got to check somebody that's talking crazy. That seemed to be a theme of their actions. What else? Now I'm like on number 17. So it goes all the way to 30 of the different things. A teacher reported that Austin lacked control and gains attention by misbehaving. This is about Hunter. Hunter was released from special ed. So he was in special education and is released from special education due to behavior. Like, that's wild. Hunter was suspended twice from school for profanity to teachers and posturing to fight, called teacher a fat ass, bitch. Hunter school.
I know you got a few more to read, but are we to believe that Hunter walked up to Karmelo with niceties? Do we believe that?
No.
One of them walked up to him with niceties.
If they're pushing people who put vape smoke in their face by accident, I can't. If somebody's telling Karmelo to leave for 15 times, you're not coming in there like, oh, I'm not going to fight you here. Why would I fight you at a track meet? Why wouldn't you? You're fighting in school. You're wanting to beat up people that talk junk at football games, basketball games. You getting put out of football game in high school. Like, what? Austin had 7 suspensions from April 22nd to April of 22 to May of 24. He was suspended 7 times from school. Austin got suspended from school after talking about bringing a gun to school. Austin was banned from basketball games for an entire season. Austin told a church group on December 9th, 24, that he was consumed by anger, lust, and addiction. He had a history of wanting to fight. The video of Austin filming, so now they get to videos that are on his phone. So they didn't have proof that any of these videos were ever sent out, but these are videos that Austin took of himself doing things, and they were just saved on his phone. So when they did a phone dump, they discovered these. A video of Austin filming a black student. After the student says stop, he hits the student in the face. This is on a recording. March 21st, 22nd, Austin has a video of him throwing a water bottle at a black kid. Austin films a black kid eating a banana in a locker room. Like, just messing with minorities, just messing with a lot of the black kids. A lot of these videos. Austin videoed himself slapping a black kid on the head. Okay, I wrote too fast on that one. It's a video of Austin fist fighting someone. So the fighting, the aggression, the anger, there was a video that showed him chasing, Austin was cheering on someone else who was chasing a black kid around the house. That was a video that was on his phone. There was also a video of Austin.
You want all this coming into a jurors to hear this. You want that. You forget that what, I'm not saying forget what Karmelo said, but you want the jurors to hear all this.
Mm-hmm. Mm-hmm. And the last one you're gonna hear, because Karmelo knew about it. So I'm gonna get to that one. I forgot I had more, but I'm on number 40. There was so many things about them. So this is number 40. There was a video of Austin saying, I'm gonna slap the shit out of Patrick, whoever that is, and then he slaps him. And he says, I'm gonna slap the shit out of Christian, and slaps him. Some other kids that he just is, doing violence to. He's yelling that he's gonna they had a video of him yelling February 5th, 23. Austin yelling, I'm going to slap the shit out of my dad, and he's not going to do anything about it. That's what he's screaming on this video. Right. So his parents couldn't even control. They had videos of Austin using the N-word, calling his dad the N-word, holding a butterfly knife, saying, come fuck with me now. Now, this is one that Karmelo Anthony was going to testify to. If Karmelo testified, he was going to testify that he saw one of them, and they're identical twins, so he doesn't know which one. He saw Austin or Hunter get into a fight with a kid that he knew, and And he also knew from this fight, because people are talking, that he was an aggressive person and he likes to start fights. So Karmelo had witnessed violence from one of the twins prior to. So if he had an opportunity to testify, he would have testified this, and this would have went to his state of mind at the time of the incident. He knows the whole time that he is being approached by both of them, because they're both there. He just doesn't know which one was fighting at the gym, but they're identical twins, that they're aggressive, that he's seen them pick fights with people. He knows these prior difficulties. He should have testified. Mike Howard should have never entered into this gentleman's agreement. So while I'm telling you the bad things that came out, Karmelo, there was a text message between him and his girlfriend. I don't know what the context of it was, right? But these are actual things that are happening to strangers. They are terrorizing teachers. They're terrorizing the cheerleaders. They're terrorizing other students. Multiple videos of them doing things to Black kids, different Black kids. So this shows that they are bullies, that they have the racist graffiti arrest. Like, it never stopped. So I don't know if I'm Mike Howard. What do y'all say, chat? Put a 1 in the chat if you get that deal and you're like, hell no, I ain't taking that. Or put a 2 in the chat when you're like, I don't know, Karmelo saying he's gonna stab somebody and lick the blood off the knife. I'm taking a deal. I don't know. After I hear all of this stuff, I'm taking it. And then too, in the trial, so let's say you do take the deal. You're going forth. You get to the point where they try to tell you Karmelo's not covered. If he gets on the stand, all of that stuff is coming in about him. The problem was Mike Howard's turn is over. He can't now go try to bring this stuff in against Austin. So now I'm bootstrapped. Now what do I do? Right? He should have never agreed to this in the first place. They said even when they brought this deal to the judge said, what? Well, that's unusual. How are y'all gonna make that happen? Even the judge had questions like, how are y'all gonna do this deal? And they were like, oh, well, judge, it's based on good faith. We got a gentleman's agreement. We handshake. So we're on the same page. Even the judge questioned it from the beginning, and that's how it broke down. So when they get into the argument, the trial's going on, and Mike Howard testified about this on the stand. He says, this is what Saturday's coming up. The state's getting ready to rest, and they're talking in the hallway. Like, they're asking Mr. Worski, how many more witnesses you got? Because they're trying to time it, because Judge Roach wasn't playing. He wanted this trial to run back to back to back so it could get done. That's why he brought people in on a Saturday. So they're having this conversation, and they say at this point, oh, okay, well, some of our witnesses aren't available on Saturday, so y'all are going to throw us off, right? So we might have to bring up our client earlier out of order. Mike Howard doesn't say, Bill Worski this time doesn't say anything. So Mike Howard says, come Monday, they're asking. So now it's the defense case, because they started on Saturday. So it's Monday. So they're saying they're in the hallway, and they make the comment about Karmelo Anthony getting ready to testify. And Toby Shook comes over to Mike Howard and says, yeah, Bill Worski just said to me that he thinks you opened the door by mentioning the chess playing on the opening. He's like, well, why is he just now saying something? Like, opening was 4 days ago, last week. Why isn't he saying something? So Mike Howard today testified that as they developed this agreement, because Russell Wilson asked him, what was the plan how were y'all going to keep each other in check? What was the plan to implement this agreement and carry it out? Mike Howard says, well, what we said was if either party ended up getting, if either party got too close to the edge or crossed the line or was getting ready to cross the line, we pull each other coattails, and we would say, hey, you're skirting the line there. You're getting too close. Come back. And so that way we would keep.
That was foolish for the defense attorney to do that. That was foolish. You leave the chance your client's life on a honor system.
Yeah. Good faith.
Right, good faith system. This is a murder trial.
Right, oral, not written down.
Right, and then I don't recall covering a murder trial where pre-trial hearings the defendant wasn't in the courtroom. I don't recall that. I'm trying to think of cases where, because each phase in the pre-trial is important for the defendant to participate.
Yes, he's legally required to be there. And if you're going to waive it judges make you put that waiver on the record, but they didn't have a record in this place because it was all off the record. Because Bill Works, he said that's how they do things in Texas. Dennis, he said that's how they do stuff out here.
I don't know. We need someone in Texas to substantiate that, because that sounds crazy.
It does. It does. Absolutely. So when they're in this agreement, and so back to that. So he says, so Mike Howard's like, we're going to testify. And he says, y'all open the door. And so Russell's like, well, what was the plan? And so it was this whole pull the coattail, give you a heads up. And so then Mike Howard's point to that is, why didn't you say anything after the openings? If that was how we were going to operate and you felt like I opened the door, why are you waiting until Karmelo gets ready to testify to say you feel like I opened the door when you're finished? You were supposed to say that back in opening so we could talk about it. Because if I did open the door and the agreement's off the table, then I need to start cross-examining your witnesses with their prior inconsistent statements. I need to start, bringing up Austin's. We need to pause, and we need to have a pretrial hearing on this extrinsic evidence, because if the deal is off, now I can bring it in like you can bring it in on Karmelo. You don't sit and mute and benefit.
And I always wonder why Hunter was not called as well. Why wasn't Hunter?
Well, that's why. Yeah, that's why, because the only reason Hunter was going to be called was to talk about the propensity they both had to like show up together and handle things together. Well, if you agreed not to bring in any of their bad acts or bad character evidence, you can't call Hunter, because that's going to be the only thing that he testifies about. But the point that Russell Wilson is making is, state, you can't wait until Karmelo gets ready to testify and say that they opened the door 4 days ago when you sat back and got the benefits of the agreement. So your witnesses didn't get cross-examined with their prior inconsistent statements. I didn't challenge your Batson argument knowing that I got N-word stuff and you're taking off my black jurors so that they don't get offended by the N-word stuff that your victim did. Like, I can't talk about that because I am behaving against the agreement. So I don't cross-examine all of this. Everybody was wondering why the judge was allowing people to answer that whole, do you think it was self-defense? Do you think Karmelo was the aggressor question? And that comes up in this hearing. And because he made an objection at first, and the judge said they're lay people, so they can give a lay person's opinion. Well, what would you normally do in a regular trial when somebody says that? You would jump up and say, you say you felt Karmelo was the aggressor. Did you know that Austin got suspended for 7 times for fighting and cussing, and that they bullied? This is when you would counteract that evidence with that. But guess what? The agreement said you can't. So the entire state's case gets to go all the way out through with this agreement in place, and they're not challenging anything. But when Karmelo gets ready to testify, they're like, oh, flag on the play. You opened the door 4 days ago. And so that's BS. That's BS. And then they start, when that didn't work, because the judge quickly shut it down and said it didn't open the door. That's when they went to the we never anticipated Karmelo testifying line. And so they get into that questioning about that being BS. And that's what I told you, Bill Worsley was about to cry about.
As a defense attorney, the decision to testify usually happens in the end.
Well, it's put on the record in the end, because the judge does have to, the law requires that to be put on the record, where the judge brings the defendant outside the presence of the jury and explains his Fifth Amendment right and ask him if he's going to testify, and he has to put on the record yes or no. And then, you sure, you go over your rights, you can't, nobody can force you not to. It's totally your right, because 2 decisions the defendant has in the case: to plead not guilty and to testify. So it's on the defendant to make that decision. And so yes, that conversation occurs, but you got to think about what's happening. And that's what the Russell Wilson is saying is the issue here. So because the state benefited all the way up to Karmelo got ready to testify, when they say, boom, you open the door, now they're saying, and we never anticipated Karmelo testifying. In order to get Karmelo to testify, Mike Howard has to go over his entire testimony questions that he would ask Karmelo with Bill Worski, so they can say, is this going to open the door? I want to ask him about this. Is this going to open the door? And they scratched out. Bill Worski stood over his shoulders, and it took him about 45 minutes to go through all of the questions. When have you ever, I've never had a prosecutor look at my questions before I hit hit it in court. You don't review and preview your direct testimony of your defendant in a self-defense case with the DA. But Mike Howard said at this point, when they're saying he opened the door and they never anticipated Karmelo testifying, he's trying to find a way to save the deal because they in it now. So in order to save it and get Karmelo to testify, they go through this together to see what he can or cannot say. So they spend 45 minutes doing that. They get it. They're back in agreement. And then the judge says, okay, what's going on? They tell the judge where they are. And the judge says, I don't think that's going to work.
The
judge says,
the prosecutor outfoxed Mike. Yeah, outfoxed him. This was, you're fighting a fox and you let him outfox you.
Yeah. And he was still playing games today up there, acting like he's so emotionally distraught because we're saying you're playing games. So Mike Howard goes through all of this testimony, gets something that they agree on, and then the judge shuts it down. The judge's like, I don't think that's going to work. I don't see how Karmelo can testify and not put in character evidence. So the door is going to be open, and that means that Bill Worski can bring in all of the extrinsic evidence against Karmelo. Now, I have a problem with that statement, right? Because as I told you all, there hasn't been a hearing yet to determine if any of this extrinsic evidence can come in. So why is the judge saying, Karmelo, if you testify, all of this stuff is going to come in when he hasn't made the determination if it legally can even come in? Okay, so that's one part.
Right, so that's two of them going tag teaming Karmelo and his attorney.
Yeah.
And you made the point.
Yeah. And Karmelo's attorney is left with now going to the back room and having to explain to this 19-year-old who hasn't been privy to any of these hearings because they were all done off the record, what the hell's been going on and what just happened. So he's got now he had, in his affidavit said he had 10 minutes. The record shows he had 30, but he's like, look, judge, if it was 30 minutes, it still was 10 because I had to go pee. I had to go to the restroom break. That took 5 minutes. I had to go through security, has to escort me through this door, through that door, and through one more door before I can get to Karmelo. So that's another 5 or so minutes. So say I had 17 minutes, 18 minutes, judge. It took 45 minutes for us to figure out the testimony, and we're 2 attorneys. So I need more time to go spend with this 19-year-old to explain to him how I done fucked up his case. Because that's basically where we are. Son, I agreed to something. I thought it was going to work. And now this is what's going on. So the judge says, no, you don't get any more time. So they explain to Karmelo quickly what has happened. And Karmelo has to make the decision whether he's going to testify. Now, Bill Worski in his presentations tries to act like, I looked at Karmelo and at the time that he was getting ready to testify on Monday, the defense's case is not going well for them. They're losing. Every witness they put up is coming on our side. They're saying Karmelo's the aggressor. He's right now. They were losing. It did appear they were losing because the witnesses at the end, because Bill Worski would ask that last question, hey, do you think this was self-defense? And they say no. Who do you think was the aggressor? Karmelo. Even their own witnesses were saying that, right before Karmelo came, they took this break for him to decide whether he's going to testify. So Bill Worski says he could see the look on Karmelo's face, and Karmelo was getting scared, and he was going to change his mind, and that they're trying to act like the breakdown in gentleman's agreement is the reason Karmelo didn't testify. But in his heart, he could tell Karmelo was getting scared and wasn't going to testify. Like, how can you tell that, Bill? He kept acting like he could tell what people were going to do, going to say the entire hearing. Like, okay, whatever. But to the defense's side, they're saying once Karmelo was told everything that happened, he's like, what do you want to do? He didn't trust Bill. That's what Karmelo called him. He didn't call him Mr. Worski. He called him Bill. He said, Bill runs the courtroom. Bill runs the courtroom. This is what Karmelo felt as the 19-year-old, this entire trial, everything. He felt like Bill ran the courtroom. He didn't trust Bill because he said, Bill in a disagreement with you. And now today I get ready to testify. Now with some funny business, I don't trust him. And if I get him to testify, he's going to say the door is open and he's going to bring all that stuff. So Karmelo got afraid of that. He couldn't trust Bill, basically. And that's why he didn't testify. But the defense says that's a problem because the state benefited by all of the stuff they left out in the agreement when it was on their side. And then they tried to muck it up right before Karmelo testified. And they're saying that's not fair. But when Bill got Mike Howard on cross, he says, now you say the deal fell apart, right? But in the sentencing phase, didn't I follow the deal? I didn't put anything up in the punishment phase. Don't you think if I entered all of that extrinsic stuff against Karmelo in the punishment phase, he would have got more than 35 years? So you benefited. This is Bill's argument. And when you say,
I'm gonna be watching.
huh?
I'm gonna be watching. I have to drop down.
Okay, no, thank you for coming up. Thank you. So Bill says when you say the deal broke down and we sat down for 45 minutes and we came up with how Karmelo could testify by making the changes to the statements, the deal revived itself. So we worked it out, right? So then the deal didn't get reneged on. It worked out and you benefited from it in punishment phase to the end. So how are you coming back now arguing that you didn't have a benefit? What did you lose? What did you give up? So that's the state's argument to this gentleman's agreement breaking down. Like, okay, we had a hiccup in it, but we worked it out. And Karmelo chose not to testify. We didn't do anything. We gave you a way that he could testify. You took it to him and he turned it down. So he chose not to testify. Nothing we did affected that. That's Bill Worski's position. That's the state's position. You bagged out of that. So, don't really know. But I think more so the gentleman's agreement, the whole point of that argument, because it never was an argument that was going to get granted a new trial, because it's not a structural error. It's just to show the public how weird this case was and what happened in this case and how stuff was kept out and all of that. So that's really the point of this argument. It's not going to get him a new trial, but it does show you the back door, the backhanded things and all of that. All right, so let me go to the super chats and catch up. And Dominatrix, speak on it. Thank you so much, sis. She was our stream sponsor yesterday, and she is our stream sponsor today. And look, it's still in the banner because I forgot to take it out. So yes, let me update it with how much. She sends a $200 super chat. No comment, no question. Pure love of the game. Thank you so much, sis. I was looking at your name today. I was like, did I say that right? So thank you so much. Shout out for that. Thank you so much. I love you guys. Y'all are the best chat ever. Thank you so much. We've been live for 2 hours and 44 minutes. It's 1,280 people in the chat. Wow. Like, share, and subscribe to the channel. If it's your first time here, I'm the Fit Lawyer ATL from Atlanta, 20-year criminal defense attorney. Flew into Collin County, Texas on Tuesday because I wanted to be on the ground in the courtroom to hear these legal arguments so I could bring them to you all and just let you see everything that's going on. Let me make sure I'm on the right super chat because y'all are jumping in the chat. Let me see. Did I read this one? Yes, I did speak on that one. Sorry, y'all. Tyrone Phillips sends 2 jewels. Let me catch up. Okay, I did need 41. All right, sorry, y'all. Just want to make sure I don't miss anyone. And then I did do Ayana. Yep, I did yours. Thank you so much. I did TK, y'all. I'm sorry. There's so many super chats back here. Okay, so Candace Duvernay, shout out. She is another Black female attorney in Atlanta, Georgia. And then one of my sorority sisters, shout out to Delta Sigma Theta. Ooh, she sends a $20 super chat, says amazing coverage. Thank you so much, sis. I saw your comments on my Facebook early today, so you've been riding with me. Thank you so much. Ayana I5W sends a $10 super chat. Social media folks said his ex-girlfriend notified the school he was stalking her and not taking the breakup well. Then an hour after she told officials he stabbed Austin. How would you defend the text message? So they spoke on that. So Mike Howard, during his testimony, shout out Ayana for the great question and the $10 super chat. So Mike Howard testified and said that's actually not what happened. So he says that he didn't really speak to the girlfriend part, so she probably did say something, but their explanation for that was that that's not how it went. And that's not what she said to the school. She was prepared to testify in the trial, and they had the text message chain. And it was this whole explanation that they were texting, so they probably were beefing about something because she sent a text on the day of the track meet to him that said, if you talk to any girls at the track meet, it's over for real. Like, so we have kind of back and forth. Mike Howard testified that Karmelo's phone died, and that when the phone died, messages that he had already sent didn't go out until the phone was plugged up the next day or synced to the laptop the next day. So it was like a blast of messages. And so maybe that was to explain the whole stalking part. But Bilwerski said the girl said that he was driving by the house. So I don't know. But Mike Howard said today that the girl was prepared to testify. They weren't broken up. And that's not true that's not exactly what she said to the assistant principal. But that's what Bilwerski testified to. So I don't know exactly what's true on that. That, we would just have to see what she was going to testify to if she testified at trial. But based on all of the stuff that was coming out about Austin, you don't make this deal. I've just never seen a gentleman's agreement ever. In a murder case, I've been practicing 20 years. I've never got presented with a gentleman's agreement. So I just think you just find ways to combat it. And the way to combat it was to have the girl to testify. And they said they had her ready to testify at the trial. Shout out to Peerless Queen. She sends 5 jewels and says, treat. Thank you so much, sis. Suave YQ7SP sends 10 jewels, says hiding. All right. And then it sends another 30 jewels, flower. Thank you so much, y'all, for the support. Love it, love it, love it. All right. Let me get back to the commentary. So Mike Howard's testifying. So he explained that whole part about, the text message situation. Let's see what else. So the state, like I said, the defense's biggest argument on this is the detrimental reliance on the agreement. But I told you the state's comeback is that they saved the agreement. So basically don't come back now. Now, also Bill asked Mike Howard, how didn't you benefit? You keep saying that we got the sole benefit, but what did you give up in making this agreement and everything? Like, what did you give up? And so he talks about, prior statements, like Austin can be a bit aggressive at a time. So if I don't know if y'all recall, Tiffany Whitaker testified at the hearing, at the trial. She was the person who Karmelo passed at first. I guess she was an adult. She wasn't one of the kids. She was an adult. She works with the school, the track, I don't know if she was a coach or whatever, but she was out there. I think she might've been like the athletic trainer or something. And so she saw Karmelo, stopped him and told his coach to kind of hold on to him. So she was going over to check on Austin. So she made statements to the police that day that Austin can be a bit aggressive at times and he has a bolder mouth sometimes. Well, Mike Howard says that's what I gave up. When she testified for you, I didn't cross-examine her on that statement. I didn't say, but didn't you say that Austin was a bit aggressive to the police? Didn't you say that, he has a bold mouth sometimes? Like I didn't do that. So that's what I gave up because, like I say, Bill Worsley kept trying to minimize it. Like we both benefited from this. I didn't bring in Karmelo's thing. I didn't say anything at punishment phase about all the stuff that he had done to try to get more time. So we both gave up things. And so Bill Worsley kept saying that Russell Wilson tried to paint it as if Mike Howard both hands were tied behind his back through this trial. And he said, Judge, that's just not the case. It was more like one hand. Like, still don't really feel too good. But Mike Howard entered into this agreement for whatever reason. Another thing that Russell Wilson did with his exhibits is he typed up a summary document of all the testimony that Mike Howard left out. So it was like, if this witness had been called, we could have crossed them on this and we could have crossed on this. So he did a summary table so the judge could quickly see, what was left out. And then they did another summary of all of the evidence that I read through about Austin and Hunter. They had a table that showed what exceptions to the rules that they will be able to argue to get that evidence in. So I thought that was very effective. So the judge could see quickly look at how this gentleman's agreement shaped the case. And that way it'll let him make a quicker decision about whether or not, this is something he needs to address in the motion for new trial. Like I say, the issue with the gentleman's agreement is not a structural error. So it won't get Karmelo a new trial, but it definitely shows light of, the shadow docket and all that kind of stuff that was going on with the case. Let's see. Let's make sure I cover everything, because Mike Howard was the last witness that testified. Like I said, we only got through 2 witnesses today. Like, that's what I'm like. Russell Wilson, if you're listening, speed it up tomorrow, okay? Because we need this to end. You all get back to legal arguments so the judge can make a decision, because the law says that the court has 75 days to rule on this motion from the day of the verdict, and that deadline is Sunday. And because the deadline falls on the weekend, it goes to Monday, next business day, which is Monday, which is why Russell Wilson, when he filed the motion, requested a hearing to be done by the 21st. He didn't want to get into that deadline because he knows it's going to take more than a day. So hopefully we're wrapped up tomorrow and the judge can, because I think he's going to have to take it under advisement, but he's only got the weekend because he has to issue a ruling on Monday. If the judge doesn't issue a ruling on Monday, the motion is denied as a matter of law. Okay. So we got to wrap it up tomorrow. Let's see. Make sure I cover everything. Okay. So there came up, okay, so mushrooms. Let me see how this went. So they're talking about the extrinsic evidence they have against Karmelo. And I told you all, they show on screen the photo of Karmelo Anthony holding a weapon. So the DAs were extremely thorough. This is what Mike Howard is saying. And so then there's a question where Russell Wilson is asking, was there a discussion about selling mushrooms? And so I guess there was a text message that Karmelo was texting somebody about selling mushrooms. I don't know if you all know, but there are mushrooms that are, that are drugs. They're not narcotics, but they are drugs, and they're illegal in most states. And I always have to, let me see, what is this word? Because I always mess it up. Psilocybin? Y'all know what I'm trying to say. That word. Anyway, mushrooms came up. So Karmelo was talking about selling mushrooms. And so then Russell Wilson was like, well, that's not narcotics. And Bill jumps up and says, talk to the back. That mushrooms are still illegal here, right? They're illegal in this state. It's like, Bill, bruh, like, it's not your turn. Like, y'all, he just kept jumping up and saying, and then they kind of, he said, they're still illegal, has a joke. And he said, I wish I could pop one right now. And I felt him on that, because it was like, dang, this is going all day with this one witness. Can we get through it? So it was kind of long. So it was like a little laugh, a little joke. And then they get into asking Mike Howard, like, why wasn't the agreement reduced to writing? Because like everything else, this was done off the record as well, which is wild. But they say they couldn't put this agreement in writing because it was so, it's like, it's kind of moving and changing as they go, right? Because we're agreeing to keep stuff out, right? But we don't know how things are going to go. So we can't just do a blanket. You can't say this, you can't say that, because it was so many things that could open the door and so many variables and hypotheticals that could come up from this agreement. So they didn't put it in writing for that reason. So Mike Howard testified about that. What else? Make sure. They went into a lot of detail about this agreement. They met in the grand jury room like a month and a half before the trial, and that was their first time meeting about the agreement. And then they just started kind of narrowing it down and going over everything. So to Bill Worthy's point about they didn't think it was going to cover Karmelo, there were times where they actually went through other witnesses' testimony to talk about what would and what wouldn't open the door. And they're like, y'all never asked us if Karmelo said this, if Karmelo said that. So it was never presented like you even consider him testifying. But of course, everybody's calling BS on that. It's a self-defense case. This boy's never been arrested before. Of course, he's going to testify because he has to testify. But because of the agreement and how things broke down in the end, he ended up not doing so. And that's kind of pretty much where things ended with Mr. Howard. Let me just... Yeah, I was trying to write down oh, wait a minute. I got a lot more. Hold on. I just feel like that's pretty much the bulk of things going through that agreement. Let me just make sure I didn't miss anything. I think I pretty much. Oh, and then it's this whole. I told y'all about how Mr. Worski was sounding as if his voice was shaking. How he was very like, you gotta know I wanted him to testify. So they kind of spent some time there because he's trying to clear up his reputation. He doesn't like the fact that it's presented as if he did some old dirty, tricky stuff here. But that's how. I mean, it's just that's how we feel, right? The gentleman's agreement. It just doesn't feel good to anybody. And he just swears up and down that him and Dewey Mitchell never thought that they were going to call Karmelo Anthony, which just sounds so disingenuous. And as someone asked earlier, Mike Howard never could really just say it. He's just like, I don't know your heart, but the more I think about it, it doesn't make sense to me how you didn't think Karmelo was going to testify. Even when you stand up and say your mentor always says that a defendant has to testify in a self-defense case, how did you think that he wasn't in this case? Bill kept repeating. This is when that little breakdown part. Let me see. I think I talked through my notes, meaning I went over all of this. So the provocation is the third argument. They didn't really get into it, so that's what we got to get into tomorrow. I know that I'm not sure. I think that's just going to be left for legal argument because the jury instruction was given. So we have the actual, instruction. So we're just going to, I guess that's just going to be legal argument. As I stated, the day ended with them saying they were going to they had Toby Shook there. He was literally sitting in the courtroom up front. Now, what I did notice is that in most times when you have a hearing when witnesses are going to testify, at the start of the hearing, you say, Judge, I like to invoke the rule of sequestration. And what the rule of sequestration means, that any witness that's going to testify in the hearing must be outside the courtroom, so they can't be swayed by hearing other witnesses testify. That wasn't said in this case. So while Derrick Jackson wasn't in the courtroom, they brought him in and he left out. Mike Howard, they brought him in, but Toby Shook was in the courtroom the whole time that Mike Howard was testifying. He was just sitting right up front. So, nobody said anything. So I guess they don't care, but I found that weird. So they're going to start tomorrow with Toby Shook on the stand, followed by, it was announced today, 4 witnesses that are going to talk about, coming to the trial and not being able to go inside. They're going to talk about this whole public trial issue. So we only got through 2 witnesses today, and that's 5 for tomorrow. So somebody's going to have to speed up so we can get through everything. And after those witnesses, then they'll do the legal argument on both sides and then rest. And then the judge will either make a decision on the record tomorrow or he will take it under advisement. But whatever decision, well, I can't say that because the deadline's Monday. So if the judge doesn't say anything, it's denied as a matter of law. But we had a hearing in this case. Judge Chitty is not going to do that. The way he came in, introducing himself, the way he put the Waller findings on the record with having Mr. Schaefer come in, he's going to issue a ruling either way. It could be an oral pronouncement of the ruling if he's going to deny it. But if he's going to grant it, he has to issue a written ruling and he has to put the findings on the record. So we'll see how this goes. I just want to make sure. We took a break at 4:30, and that's when Bill started his cross of Mike Howard, which I kind of talked about, and we actually, I think, wrapped up about 6. Just want to make sure. And once again, when he was crossing Mike Howard, he took digs at the content creators. He said the influencers, the disruptors, they wanted to. Oh, he said at one point they were actually thinking about calling to the stand some of these influencers / disruptors who were putting out, to what the state said, misinformation, that they wanted to call them to the stand, swear them in and put them on the record and cross-examine, and examine them and figure out where you're getting this information and all of that. But the judge didn't want to entertain it. Isn't that wild? That's wild to me. But anyway, Tiffany Billion's names came back up again. And then he said to Mike Howard, I hope you don't know her personally. But she went live every night on TikTok. He mentioned Sarah Fields and says that Mike was against her. So the feelings that Bill Worski had against Tiffany Billion. He says Mike Howard had those same feelings against Sarah Fields. They said that pictures were put in there. Pictures were there. Pictures were then put in AI by Christopher King. Okay, let me go back to that. Let's see what they were saying. Something happened where some pictures were released or something, and they were Bill Worski. And mind you, this is when the defense started to object, right? Because where did you hear a question? He's just making statements. Oh yeah, then Christopher King got some AI, got some pictures and put them in AI and put those out. And it's like, what? Where is the question to Mike Howard? And so at this point, the defense starts to object. They're like, Judge, we let this kind of go on too long, but he's testifying. I don't hear a question, objection. So the defense really started to object a lot in the last 30-40 minutes of the hearing today, because Bill Worski had been doing this the whole time. I put it in my notes. He's testifying. He was on a lot of that from his seat. And so they finally started objecting to that. Okay. And so then they came up at this point when they mentioned Christopher King. Mike Howard says he got so many emails from Christopher King that he started a rule in his email box, so they will automatically go to another folder. So I'm not sure what all he was emailing, but he was emailing everyone in this case. So then Bill asked Mike, so when you say that the trial went off without a hitch, and then it was like this awkward silent pause, and Mike's looking around like, I can't really say that. What do you mean by that, right? Because we just got to talking about this big ass hitch with this gentleman's agreement that went awry. So I don't agree. And then, they had to clear that up. And he's like, well, the trial wasn't disruptive is what he had to come back and clarify. He's like, well, I can agree there. The trial wasn't disruptive. And then Bill Worski gets into talking about how the judge afforded the client Karmelo Anthony, because remember, he's on bond with the trial. They gave him guards. They could come in through a back door. And he even made a point to say, surprisingly, this new defense team, they're doing the same thing. They're taking advantage of this backdoor access and the guard walk in too. I don't know why they're not getting threats. And it's like, Bill, focus on the issues, please. It was just a lot of pettiness and making comments about stuff, because it's the first time in court since the verdict, right, outside of the motion to recuse. This is the first time he's able to address everything that's come up in the public. So he's been definitely paying attention to everything on social media, everything people have been saying about this case. And he used this hearing to make jabs at a lot of things that have come out, because his reputation means a lot to him. So look, I'm on my second notebook today. Fast I was writing, I'm like, oh, let's see. Bill's whole point is just point out that they, they both sides benefited from this agreement. And then I told you all, he had the moment where it sounded like he was crying when he's like, did you really think I didn't want your client to testify? He wants Mike Howard to answer this on the record. He asked him about 3 or 4 times, and the last 2 times his voice is shaking. His hands are shaking. Like he sounded like he was crying. Like, he's like, and Mike Howard was like, it really doesn't matter what I think about your actions. The point is, he's like, it does matter. My reputation matters. That was very important to Bill. And I get that, they're saying like, you did some underhanded stuff, and he's adamant that he didn't, but it just doesn't pass the smell test on this whole, you didn't think Karmelo was going to testify. And that was pretty much it, guys. Today they wrapped up. They talked about some additional video that came out May 8th. That a May 8th additional video that originally wasn't given to police. So I don't know what video that is. I'm not even gonna speculate, because it can't be this Frisco ISD video, but some new video came into play May 8th. They didn't really get into the details of that. And that was pretty much it. We ended the day with Mike Howard, and then the judge clarified, like I said, who all was going to testify tomorrow. And then, about this agreement, Bill just basically towards the end of his cross, just wanted to drill in that the defense benefited from this agreement as well. He's like, none of your clients' 75 pages came in, right? So you benefited, right? Okay, so like, what are you arguing about now? And so Bill's whole take is just like, look, the attorneys in this trial agreed to everything. We did things how business is done in Texas. We have a lot of off the record conversations about cases here in Texas. This is how stuff is done, and everybody was fine with how everything happened in this case until this new appeal team comes, and now they got a problem with everything. But Judge, everybody was happy with how everything happened when it happened. Everybody was in agreement. The defense waived any arguments they have about this because they didn't object to it during the trial. They actually went along with it. So, and that's really going to be the deciding factor on the Waller issue, because as an attorney, I can tell you the state did not put Waller findings on the record. Bill Worski never made an argument that they did. He just simply explained why things happened the way they did. And a lot of it was about the safety of Karmelo. So, but the judge is going to have to find that the defense saves this objection, that they made it or didn't know to make it in time, right? Because Mike Howard says stuff was happening about who could come in and out during the trial. I can't keep up with that until after. So that's going to be it. So if the judge finds that they made the objection in time, then I believe the motion for new trial will be granted on the Waller finding issue because they are missing. So that is a structural error. The appeals court, Supreme Court says that in Presley and Waller that is a violation that grants the defendant a new trial. But the first part of that is, did the defense waive this objection or not? So hopefully we can get through all of the witnesses that testify tomorrow and we can get a response, okay? I had to change my flight, change my rental car, add a room on a hotel because I thought I was going to be flying back in the morning. But no, in the morning, I will be lined up at the courthouse to try to get inside the courtroom once again. Let me go through the remaining super chats that are coming in. Let me see where I stopped. All right, Sagittarius Love 2492 sends 10 jewels. Thank you so much, sis. Miss Bree 9690 sends 10 jewels. TKO Every Time 19 sends another $5 super chat. Shout out. Thank you so much. WFAA, which is a local channel here in Texas, claimed that Howard said he would have waived public trial for security purposes. Is that true? Isn't that undermining the basis for appeal? Yes, he did say that. He says that during one of their meetings, he did say that he would waive public trial for security purposes, but like that never was put on the record. Nothing was ever filed or signed. And so then he says, hey, and so then Bill Worski says, well, didn't you waive the issue? And that's why I say the judge is going to have to see that they give up this objection. They give up this right to make this argument. And so then what Mike Howard says is things occurred with the closure and people were kept out during the trial that I wasn't aware about. So while I was fine with the amended order, I wasn't fine with how the amended order was put in place by Mr. Stoller. And Karmelo's grandmother wasn't able to come in. Like people were it was said they were going to have 15 seats, but they only got 8. So those things happened during the trial. I can't focus on anything but the trial. So I didn't have an opportunity to object, nor did I even know about it until this research that the appeals team did and people filed affidavits. So while I did waive public trial for security purposes, I didn't waive my argument on how our restrictions were being managed by the public information officer. So that's why I say this is the sticking point here. So this is depending on if the judge feels like he waived the issue or did he not waive it because some of the restrictions were occurring during the trial. The fact that the trial started the first 2 days with jury selection in the overflow room, and then when testimony started, it was gone. So he's going to look at that to make that decision and see whether or not the defense can even bring this argument. So that's what I just said. That's the first part. Can they bring the argument? If they can bring it, they win it. King of the SWAC sends a $20 super chat. Thank you so much. Says, thanks for checking on me this morning in line. This Phi Beta Sigma Black Panther was about to destroy Sippy Cup. So thank you again. Oh, shout out. wow, okay. So this is Nick and Knight. This is the Black Panther that provides security to Nick and Knight here. See you in the morning. Save me a seat if I'm late. But and there was some drama going on. Fit is in the courtroom representing clients, so I don't know what's going on in these YouTube streets, but there's drama. And so King of the SWAT was there to protect Nick and Knight, to shut down what was going on. I mean, he was like in a stare-off contest for like an hour and a half, but he made sure that we all stayed safe and that no drama popped off. And I did just kind of touch him on the arm, like, you okay? Just to make sure we're straight. So shout out. Thank you so much for this $20 super chat. Thanks for, I got your back anytime. You looked out for me day one when I pulled up into the parking lot about 6:10, 6:13. Dennis was already calling me before 6, like, Fit, you there? I'm like, I'm on the way. And as soon as I got the car, I'm kind of lollygagging because I'm like, oh, okay, I see people over here. And this Black Panther brother said, you got a card, sister? You got your card? I said, what card? He said, go get a card from the sheriff. I'm like, okay, I'm on the way now. And I was number 37. So thank you. That's how I was able to get in the courtroom on yesterday. And so I was in place on time today. So look, you got my back, I got your back. Thank you so much for tuning in. Shout out to Tanaya Johnson, 5957, sends a $10 super chat. Says that Russell Wilson team seemed intimidated by Bill Worsley. Absolutely not. It seems like he was still running the courtroom. No. Now, Bill's going to do his antics, right? He's going to do his thing, but he wasn't running nothing. I don't know if you were here at the beginning, but I talked about when we first go in, what I noticed, Russell Wilson got a box of evidence on the table. Boom. Each attorney's at the table is him, Mike, Justin. They got 3 folders in front of them. They are prepared. Bill Worsley had like a little white binder because he doesn't have a legal argument, really. Like, he's not putting in exhibits. He's not putting in all this kind of stuff. He's just defending what already occurred. So no, absolutely not. Russell Wilson, never. No, that dream team comes in there standing up tall and strong every day. No intimidation whatsoever. Now, Bill makes his outburst and all that kind of stuff. And Russell Wilson, we know he's up. He'll have a little comeback to it. And some questions will go by and he'll throw a little dig too, right? But no intimidation at all. None at all. Shout out to JWatch0622, sends a $5 super check. I work in CBA law. Do you believe some paralegals know the law more than attorneys? Yes. Because you got new attorneys. You got some people that have been attorneys 5 years and they do real estate. And they got a paralegal that's working in the courthouse or they're doing criminal. Sometimes they can know more. So yeah, definitely. Because you're doing the grunt work as a paralegal, right? You're typing up all the pleadings, you're filing the documents, you're doing all that. So yes, there are some paralegals that know the law more than attorneys. And sometimes as an attorney, when you're getting your own practice started, they tell you, go get your old school paralegal that'll help you. Okay. You should see how many judges have their staff attorneys informing them on what to do, what not to do when it comes to family cases and criminal cases all the time. So yeah, just because you're the lawyer doesn't mean you know everything. So yes, there are some paralegals that know more than attorneys. So shout out, y'all. I'm going to wrap it up. We have been on live for 3 hours and 15 minutes. I got to be up early in the morning, a few more hours. I got to jump back up so I can go get in line to get into the courtroom for the day 2 of the motion for new trial. So thank you so much for tuning in for the commentary tonight. I think we were over 1,000 people in the chat for a long time. So, oh my God, that's amazing. Where all the jury was, I know it was a multi-ethnic pool. Yes, were all the juries U.S. citizens? Yes. And there was a big ethnic pool in the juries, but that's what makes up Collin County. I think Black people only make up like 13% of Collin County. And I think it's a big Indian population here. I believe that's what it is. So everyone has said, well, I've heard a lot of people say that the jury pool, the pool to choose from, like the 600 people that came, that was a reflection of Collin County. I can't say that the ones that actually sat in the box per se, because we had the 3 Black jurors that were struck, but no, the big pool that they chose from, they said was representative of Collin County. So yeah. All right, y'all. So thank you so much for tuning in. Make sure you like, share, and subscribe to the channel, and stay tuned tomorrow. I'll bring updates first thing in the morning from the line and during the lunch break. Hopefully tomorrow wraps up earlier, or if we go long, hopefully we get a decision, because as I state, the judge has to rule on this by Monday or the motion is denied as a matter of law. All right. So it's been great having y'all here. I hope you learned a lot from this live. I saw some people that watched the live last night at the courthouse today. So I hope y'all see y'all again tomorrow there for support. Thank you so much. It's the Fit Lawyer ATL, and I'll see you in court.